Why? Next week. Learned counsel for the petitioner prays for adjournment list appellant prays for adjournment list after 2 weeks. Yes.
Item number 47. Trying to post option 483.
What is it, madam?
I think to find the petition not to construct the rice mill in the concerned. We
Learned counsel for the petitioner
My
prays
lord,
and is
my
granted.
lord, I am for the respondent number 5, my lord. Already the case is in process, my lord. Petition is considered by the respondent.
Let it be called. It will definitely be called, madam. Don't seek adjournment. He is opposing the prayer.
Item
43, page 4, item 43. Lordship, this matter seen and considered. The Reddy is appearing in Lordship, personal conveyance, Lordship, may have tomorrow.
Who is appealing?
Reddy, senior consul. Lordship, some personal inconvenience, Lordship, may have tomorrow. Item 43.
What is it? All right. So tomorrow means not possible to add like this. Day after tomorrow?
Yes. Yes.
Learned counsel for the, what's your name?
Reddy.
Ravindra Reddy, learned counsel for the appellant, prays for adjournment on the ground that the arguing counsel, Mr. Satyanarayan, is unwell.
Reddy.
Satyanarayan is unwell. He therefore, Rachana
Reddy.
Rachana Reddy. We had a counsel in Satya there, so I thought Rachana Reddy is unwell. He therefore prays for adjournment list, whatever. Day after 10th August. All right. Fine. Yes. What happened? Tomorrow. Today you can manage, right? Tomorrow. You will not hand over the charge so easily, right? So, tomorrow. Not lunch motion.
Your Lordship, this bill has to post it today. I don't know what is disappear from the list, sir. Bring to notice.
No, there's no question of disappearing. There is no mystery being like this thing about.
Sir,
Human elements are at this thing work. No, human beings work and prepare the list. So don't say disappeared and all that. We will look at what is the date, Mr. Why it has not come up. We will find out, Mr.
thank you, sir. Please. Election is
We are doing our best, you know.
because the contest to elections is coming. It's the right time to advise the opinion body, HIGHCOURT, to HIGHCOURT. So that election commission will be decided.
When the date was given, so
Today.
when
Earlier 67 was there. Case has posted for this day. Your Lordship, the judgments of
see.
directed me to
It's there in the list, Mr. You don't know. It's item number 19 in the list. That shows Mr. 13%. That shows the urgency and the serious approach with which you are pursuing a public cause, right? This has happened for the first time in my career spanning over 14 years that a party is making a request in respect of case already listed. You are prepared to give a speech to us about democracy. You don't know what your case is listed. Strange. Yes. Day before yesterday? Huh? Huh? No, no. So what is the urgency? Substitution of LRs. Huh? What do you want? I mean, for what purpose you want listing that you must tell, and urgency? No, so you have filed some IAS restraining them from dispossessing you. No, it will come up on a mention memo only on an interlocutory application. So we are asking you that question. What is so difficult about it? Is it, I mean, something we are asking which is not understandable? You ask that I am not getting what Lordship is saying, that I will explain.
What is the matter? What is the urgency? We are trying to understand. First address it in the mic. We are unable to hear you.
Restore the name. The district collector did not restore the name of the petitioner even after
So any interlocutory application pending for orders which is required to be listed, because by way of a mention memo, we will not list your petition for final hearing. Got it? You have to, if you want, if they are trying to dispossess you, file an application restraining them from interfering with your possession, then move a mention memo. We will list on that IE. No final hearing through mention memo. Correct? Yes.
May it please, Miller. Miller, the contemner has collected an amount of rupees 22 lakhs excess, Miller, from the student.
One.
Yes.
Computer writing. Monitor that is recommended. I am shifting every day inside. Still bigger. I got it.
So that.
So the screen should be this.
Slightly.
छोटा जब पार्टी अप्रोच करते हैं वो बड़ा होगा वो पहले बड़ा होता है तो मैं तो उनके ऊपर चेहरा इतना
Can we have a history? Can we have a slightly bigger
मॉनिटर वो
slightly bigger monitor also? You put it.
तो पार्टीशन जो स्क्रीन में इसी किसी छात्र जो है वो स्पेंडिंग करके बात करेंगे और थोड़ा उधर सकता मैं बोला ना इधर खाने में और सब और थोड़ा अभी हाँ साफ के देखिए इधर थोड़ा इधर और पर हाँ हाँ
Oh, yes, Mister.
Yes, Miller, the contemner college has collected an excess amount of 22 lakhs from the student, Miller. There is a direction from this honorable court, Miller.
Where is it? In your writ petition?
No, I am not a party to this writ petition, but I filed a leave petition, Miller. But it is a public interest litigation, Miller, where it is, Miller, it is a public in rem, Miller. The aggrieved party can approach this court, Miller, for their redressal of their grievance, Miller. I filed leave petition also, Miller.
You are an aggrieved person, right? You can file a writ petition.
One submission, but if I file it, the same order, the same order will applicable, Miller.
No. So you have to get an order. You cannot jump one stage by straightway filing a contempt petition. There has to be an order saying that, there has to be a finding saying that contempt is personal in nature. There has to be an order saying that from you excess amount of 92 lakhs or 1 crore has been recovered, and this is in violation of the order passed in pill, and therefore respondents are directed to refund the amount to the petitioner along with interest. If that is not done, contempt.
But here in this matter, Miller,
Why don't you-
petitioner is not
it's-
taking any
it's-
interest, Miller.
The example, we gave an example.
One submission, Miller. If
So it
if a
doesn't
public
mean the
interest
answer
petition
is, answer is not that I am not claiming interest.
one number submission, Miller.
No, if you want to pass an order, we go ahead, you see our order. You have understood, you knew at the time of filing of the contempt petition, what is the position in law. If you don't want to assist us,
I will-
any case law,
Some judgment, Miller.
then you,
Yes, Miller.
there is no order, so contempt does not lie.
First of all, there is no determination
You are right.
competent authority as to whether there is an excess amount of 22 lakhs collected from you or not. Somebody has to determine, your mere assertion cannot be taken as
I gave legal notice also, but they did not reply, Miller. They admitted the fact.
Withdraw.
There is no point in.
Withdraw, there's file a petition. It is your case is supported by division bench decision. Say to the judge that I want a similar order, simple.
One misfortune, but this
All right.
petitioner has not approached the court in
Fine. This petition has been filed for non-compliance of the orders dated, non-compliance of the order dated, which order? Order dated 19/1/2022, WP number, WP
Wait,
2017.
This appeal is filed with an application.
Yes.
Brief for respond number 1.
This appeal is filed by a third party to the writ petition.
Elected.
Weaving is okay.
Weaving mills,
Weaving is small.
scale industry,
Smaller.
scale industries.
They're all actually domestic industries in Canada. Their power consumption is not more than 10 horsepower.
Yes, right. What do you
Brief
say?
for respond number 1.
Ah,
I request time for filing counter leave petition.
we are granting leave petition. You are filed caveat.
There. Yes,
You you have filed caveat.
Petition, petition.
No, you are on caveat
Once more.
advanced one.
I have the
So then,
petition.
Mr. The point is that the relief has been granted against small scale industries.
Yes.
Those 127 small scale industries were not included in the petition. Neither petitioners who are appellants who are similarly situated like these small scale industries were impeded. So how can, in their absence, this can be adjudicated?
Well, the
Arey,
petition,
Mr.
no,
See.
your lordship, appellate before your lordship.
Is he making a video?
Appellate,
Adam, call that counsel. Come here. You come here. Behind you. Please come. You come. Are you making a video? Then what are you doing like the mobile phone is permitted? That doesn't mean that we don't know whether you have made a video. Don't be cautious. If you have to call, send some message, do it. Don't this thing. It is visible to us. We thought that you are making a video.
We have live streaming. You don't need to take the trouble.
Live streaming, right? Ask your whosoever wants to see the proceeding, he can join. Don't do it.
my only submission that the order passed with a letter single is applicable to only small scale industries units. They are not before your lordship. They are now they filed for individuals.
No, you did not implement them also. Even one was not made a part.
No, your lordship can see that that order is applicable to only units, SSI units. They are the agreed parties, but they are not before your lordship.
Mr. Venkateswar, it is 10 horsepower is the outer limit. You did not say that, not even about a whisper about in your affidavit about now a single person having more than consumption, more than.
It is there now. Your lordship can see page 34. Prior to filing the petition, they have
No, you want to this thing, we will dispose of this appeal right away by saying that it does not apply to 127 small scale industries as well as the appellants. So you are saying that it does not affect them, therefore appeal does not lie. On this ground, you want to oppose his prayer seeking permission. So we will clarify that it neither applies to appellants nor to 127.
No, I leave it to your lordship regarding a leave. Regarding granting of leave, I leave it to your lordship. I will file a counter because now they are not.
There is, in writ appeal, there is no counter. No provision of law permits you to file counter. If that is so, please, we have been asking everyone, this is.
I will argue the matter, Milad. Just I want to one week time.
Nothing, it has to be remitted, you know it. It can't be, you implead them, it will remain pending here for 5 years if you entertain it. You better, this thing, you implead them, implead the petitioner, get an order.
No. My only submission, Milad, page 34, your lordship can see.
Or otherwise, if you are not seeking relief against 127 people and.
No, they are not. No, they are not SSI units, Milad. They are filed independently. Your lordship can see
So shall we say that it does not apply to the appellants?
Yes, Milad, not parties, not individuals. This is only for units.
No, I mean, so, no, you will seek get an order from the single judge without impleading necessary parties and will say that they are not parties.
No, your lordship
No, you tell us why your writ petition should not be dismissed for non-joinder of necessary parties. I will on the next date.
No.
Learn it. Got it, Mr. Learned Senior. We will dismiss. Adopting your writ petition for non-joinder of necessary parties. You argue on this. We are putting you to notice. Heard on IA number 1. Comfortable now. Yes.
May I please, may I make word submission? We have 6 and
You
7.
file objections to prayer for in this thing. If you want to contest, we have granted an ad interim power.
My lords, earlier to these notices, my lords, we have issued the earlier notices, my lord, that has to be come into the effect.
File reply on the next date. File whatever.
Obliged.
Now we have given a short date, right? 22nd August. File counter to his IA by next date.
Much obliged.
Obliged, my lords.
So you have to people ready.
May I please, Lord, the appellant's hearing, Lord, a third party to the writ petition.
Hmm.
But writ petition has been filed by the first respondent.
Dispute pertaining title is pending invoice.
Yes, but that can be something in next. Kindly look at there are 4 page 8 and 9.
Which?
Next. No. Next page. By putting all the parties concerned.
Lord, sir, writ petition has been filed by the first respondent, Lord, by
Read para 4. Para 4. You want to say that dispute pertaining to title is pending invoice 480.
yes, my Lord. That's-
480/23. You can bring this dispute to the notice of this person, whosoever is doing.
Lords, in fact, my Lord, even, my Lord, as on date, the official order copy has not been yet prepared. Despite of it, my Lord, a notice has been issued, my Lord, for conduction of survey.
No, RDO and deputy inspector, we will direct.
Several,
Just a minute.
I'm sorry.
Before conducting survey, they will they will issue a notice to you, and you will be at liberty to bring to their notice that a dispute of title in respect of land in question is pending OS. In OS.
Has already been brought to their notice, my Lord. Despite of that, my Lord, they are going ahead with the survey. My Lord, that is my contention, my Lord. Even before the preparation of the order, my Lord, which is implemented,
No. So what does para 4 say? If they are ordering survey means directions have exhausted, issued by, it has been acted upon. Challenge a fresh petition.
Lord's,
File a fresh petition instead of appeal.
my Lord's,
Say that this order, in that petition, you say this order doesn't bind me because I am not a party. And then this XYZ reasons survey cannot be conducted.
Lord's, my,
In a writ appeal, we don't decide this, right?
Lord's, my only submit, my Lord, my only sub,
Yeah.
Lord's, this is not, my Lord.
No. What happens, Mister? You are the owner,
Yes,
right? You are the owner of
and
the.
my,
Just
sorry, apologies.
listen. You are the owner of the plot. In this writ appeal, we will not issue you this thing declaration that you are the owner.
Yes,
Now the issue in this appeal is confined only to carrying out survey.
survey and subdivision, my Lord's, Lord's,
Survey. So,
survey and subdivision,
Survey
that
and
is my,
subdivision.
that is my grievance.
ah,
Survey and subdivision and,
no, there is no direction for
the
subdivision.
application which they have
Ah.
made the application which they have made is for survey and
So,
subdivision.
Mister, what happens like if a survey is conducted? It's an open plot. They were not entering your residential home to carry survey.
It's not agricultural property. No.
Agriculture,
Right.
open land, right? So they are conducting survey. Mere survey. Listen, we want to express our doubts, then you answer, right? So mere conducting a survey divest you of your title.
Had it not been so, my Lord.
No. Please tell us.
Yes,
Answer.
that's, I'm coming to that.
Your title will be lost if they carry out the
No,
survey.
my Lord, absolutely not.
Then-
Had it been a mere survey, my Lord, I would have not ventured for filing an appeal before this honorable court.
Ah.
Had it been it for mere survey, it is for survey as well as for subdivision of the property. My Lord, and my title, I am questioning their title itself, my Lord, it
No,
was pending dispute before the
But
concerned
please,
civil court.
Mr.
But has been suppressed.
One, learned single judge has decided title.
No.
It said that the petitioners have title.
No.
Then how these revenue matters, we want to ask once for all, because we have repeatedly coming across revenue entry, this. Supposing if it is made against you, what happens? You are gone, title extinguished. But this revenue entry, everything, we will clarify that this survey will be subject to OS of result of OS 480 of 2020.
It's instead of that, my Lord, let my representations which I have given, my objections, that to be
Objections, so that's correct. Objections to whom?
objections, my Lord, I have given to the
To whom you have given?
I have given to the,
When have you given?
I'll give the dates, man.
That's what you should.
Your Lordship may find it at page from 44, my Lord, I have given the representation.
44 date.
The date, my Lord, it's on, one is representation is on 26/6/2023. Other is 28/6/2023. and other is 27/6/2023.
One is not enough, all three.
In fact, it has been given to, it has given to.
Brilliant ideas strike you later sometimes. So one idea and one, another one improvisation, third one like. You
I
decide
needed- Only the thing is,
before carrying out survey.
My lord, I am for the writ petitioner, my lord.
So you will also be heard.
My lord, I have already filed my title deed. The e-passbook is there, that is in the writ
No,
petition.
no,
at page number
again, we will have to carry a separate session for you. Separate session. What did we tell him? Do we decide the title, your title?
I am not even a party in the said suit, my lord. I have, in the same title, my lord, the cost.
No, but he has, if you are carrying out survey and want the land to be subdivided, he has a right to object. The authority will decide. We are not saying anything. You understand? We are only disposing of the appeal by saying that his pending objections shall be dealt with. You will also be heard. This is not the scope of the writ petition.
My lord, because they have to fight like a-
He is not a party in this.
But we can file it.
You can file. So you file under one rule 10. Under one rule 10 is what?
Ask an implead petition of the suit or not. Today you know that there is a suit pending. Can you file a implead or not?
in fact, a memo has been filed by them, my lord, getting it
Wait,
declared.
wait.
My lord,
Ask court everything, right? Division bench will tell you what to do.
my lord,
This is not the way to argue. Mr. What we are saying that we are sorry that whatever we told to him, you have to be told separately. And we are not sitting here to convince you, Mr. Please, one thing be sure. We interacted with him. You must have heard what we told him. Question of title is not involved in this. And you shouldn't come for everything at the drop of the hat. File a petition under Article 226. If they were not conducting survey, you could have approached a higher authority. Had I been a judge dealing with your petition, I would have said, go approach the collector instead of filing a writ petition. This all, you just submit an application. They don't do anything, file a writ petition behind anybody's back, you get the order, and this is nothing. We are only saying his objections will be decided. While deciding his objections, you will also be heard. Who will be deciding your objections?
Lord, it's the Mandal surveyor, my lord, who is arrayed as
Mandal
no, fourth and fifth respondent, my lord.
R5. Both cannot decide, Mr. One of them has to decide.
It's the fifth respondent.
So, revenue divisional officer. No. Deputy Inspector Survey and Land Records is 6. You don't know, Mr. Who will decide your representation?
Lord, survey has been conducted by the fourth respondent, my lord.
Whom have you made the representation? No.
I have made my representation to the Tahsildar as well as fifth respondent, sixth respondent, and as seventh respondent.
So who will decide, Mr.?
It's the seventh respondent who conducts.
He is higher in rank. Higher in rank. Higher in rank than Tehsildar.
He is the survey department. He is
Lord,
entirely.
They are able to tell who will decide.
Survey is conducted. It's the validation of this thing.
But who will decide? RDO.
No, RDO is not.
He is a Tehsildar.
Tehsildar is only based on.
Who will decide?
This one.
6. Deputy Inspector Survey will decide.
Sixth respondent.
Correct. Mark the presence. Heard on IA number so and so. 11 PM in the night tomorrow.
4 days,
Today
sir,
night.
because they stay in a different place, so I need to communicate.
That's what when we asked, that means give an agreed date.
If.
Huh? 14th,
14th day.
16th August 23, along with a copy of the order.
Mainly one more question, but not you.
So this applying application I can make. The other party can also make. So both come without meeting the other party to the facility. Come here, they can modern it. They should develop some system in the applying application. If one applying application is filed, if other is also trying to file it, so it's already filed, you want to record some the protest or something so that he will know.
So this is, Mr. What you should do is, as suggested by brother, what you should do is that evolve a guideline for deciding with F-line application. What will happen? He is claiming title, the case is over. We are telling him, the case is over. Don't be, he is so anxious, not even smiling. Case is over. So see, he is the like landowner, he is another person claiming title. Both of them will separately file a F-line application. You will not decide. Both of them will separately file writ petition without impeding each other. So if somebody, you put in a system in place that where somebody files an F-line application, you say sort of notice that bring up to public notice that such a such applicant person has filed an F-line application. No, do, if it is, then it needs to, your officers need to be sensitized about this if it is already there. And supposing if another application, then you should perhaps consolidate and decide them together. And here, so this will minimize the litigation, no? Correct?
Srikanth, what we are trying to say is it's all system driven. F-line is a system driven. So today, if A files a F-line application and B is also trying to file F-line application for the same land, the system should itself say that already an application is filed, therefore you record your protest there so that he is aware that, you see what is happening is we have been seeing each party files a one F-line application. After 1 week, they file one writ petition and take an order saying, please consider dispose my F-line application. So this multiplicity of litigation, if your system is foolproof enough to record that already it is pending and the other person also records his request there, both will be given notice so that there is no requirement of this multiple writ petition.
Yes.
Let's make one last.
Current permission.
SLP now, yes. Delhi.
Only thing.
There are circulars issued by the Commissioner for Survey and Land Settlement Records.
Circulars won't help. Who will remember circular? The system should.
No, Mr. You want to evolve a system, you are revenue authority. Then we are asking him, he will do it. We did not ask you to do anything. You are a citizen. Yes. Section 80 of under section 66 to 48. Say that mistake that you have entitled to use.
The section 64, they disputed and sought for reference.
So then what is the recorded finding? No, everything management.
Option of supplementary appointment. Supplementary.
See, you are in. One of the taken reports from the vending. That's where it would be nice.
So now then this 40, whatever their entitled benefit under 40 can also be considered in the section 64.
Yes. Yes, learned counsel When the court is passing an order without hearing you, you should be more than happy, madam. So you want to argue, you go ahead. Please, what, may I, what, yes. Yes, yes, please, please, please. So what, no, no, please. Please, what do you want to? We will hear you, madam. We are under an obligation to hear you. No, no. Instead of doing all this, madam, please say what you want to say. We are hearing you. No, no, please say. What do you want to say? Please argue. Yes. You have filed an application for condonation of delay. How many days delay? Acha. Why it should be? What is the point involved in the appeal? Hmm. That's what we would have exactly dictated if you had permitted us to do so. This whole exercise is, madam, to save time, nothing else. That's why we go through the files, make notes. Don't you feel that we are ready with the case? Fine, fine. That's okay. But don't say 3 times, not necessary. I am just saying now that we would have dictated the same, that since he has already taken recourse to section 64, therefore direction issued by learned single judge in passing a supplementary award. Yes. No, that's all. It's over, madam. Don't, I mean, please don't.
But there is difference, my lord, in going before
All right, so-
statutory authority.
What?
My submission is this.
So you
Statutory
are,
authority cannot direct a
minute.
supplementary award to be passed.
you are appearing for 1 to 8?
By the petitioner, madam.
1 to 8, right?
Yes, madam.
So
My
we
submission
condone
is-
the delay. What do you say?
My lord,
Condone the delay.
You have objection for the delay.
Yeah, very
We
well,
are on delay.
very well, madam. Very well, madam.
Heard on IA number so and so. Is accepted by so and so. Our submission will come first. After condonation, then admitted for hearing.
May I submit, my lord? It could be, my lord so pleases, it can be disposed of, my lord, by directing the authority
Ah,
to take into, why
everything. Ah,
keep it
correct.
pending, my lord?
Oh, yes, correct, correct. That's the better this thing. We thought that you want to seriously contend. That's what
Only
also.
one submission, my lord.
See,
Only one submission.
just a minute, we will clarify that authority dealing with your claim under section 64 not only will deal with your claim for benefits under
Additional-
40.
And also, and
45 and all other benefits.
and other, specifically section 40, subsection 5.
Yes, correct.
It can be discussed.
Learned senior, admission, delete her submission. See, madam, learned senior counsel. That respondent number 3.
Lord's kind notice.
Huh.
Why the learned single judges pass the direction to pass a supplementary award is that because the award has already lapsed. The notification has lapsed under section 25.
So that we don't know if it is open for you to
My last my
change.
time. Under
But
section.
you agreed, right?
I agree, but
So-
my lord, 25 also, the provision of section 25.
All other,
also can be raised.
all other provisions.
Specifically,
we-
section 25. May I read?
No, if permissible for you to raise, whatever is permissible can be, we cannot direct by this, we cannot by our order create jurisdiction on an authority.
Because that was
No,
specifically.
then we will have to admit this appeal. If you want to adjudicate that the lapse it has lapsed and therefore supplementary award. This judge only says benefit under 45 not paid. He has not said lapsed. You file review.
The learned single judge did say that it has lapsed. That's
No, but it's 64, can we decide?
RF
Uh,
39.
Which provision, Mr. 64,
25.
can he decide this whether or not it
That's
has
why,
lapsed?
my lord, he said that he cannot decide this lapsing.
Then he is saying that,
That's why, my lord, the learned single judge said,
then delete, Mr. Then you should, why did you say that it be disposed of like this? Now you are coming up with better ideas, right? We were admitting the writ appeal.
my lord,
The whole purpose was to save time.
yes,
This
my
is
lord.
what it's, that has been frustrated in the process. We did not permit her to speak one word, she felt aggrieved. And the whole thing is we have lost, so better we should keep quiet now. So
Now I'll keep quiet. my lord.
no,
Now I'll keep. And he reads.
We are admitting
25 and I'll keep quiet.
we are admitting the appeal then. Delete everything, Mr.
my lord.
Delay condone.
What happens is this, my lord.
No, don't change time now. This thing, now we are altering it. You urge that it is lapsed or whatever. We will decide this. The order to this extent cannot be entertained. We have already recorded.
My lord,
Everything you write, everything.
My lord, may
Then you say,
allow it to stay, my lord. My lord, may allow it to stay. I try to
Huh?
agitate before the authority and see what best can happen. Then thereafter approach this honorable if I am aggrieved. Let it remain, my lord. Because
no, you think about
number of years are passing without any compensation. That's my worry. They are all poor farmers. Their land is acquired at a throwaway price.
No, Mr. This, please appreciate that the issue with regard to lapse of award cannot be adjudicated under section 64.
Yes, ma'am.
You should, this is only with regard to measurement, amount of compensation, person to whom payable, like section 30 of 1894 Act. Rights or rehabilitation settlement, and this is the additional thing under 2013 Act. This can be, it can't be, he can't decide whether award has lapsed. If you want to contend, then we will admit it and decide.
Very well, madam.
Huh?
Without passing any interim order, my lord, lordship say only admit. Because ultimately, on the face of it, it has lapsed, my lord.
No, we will have to stay that part which says that they should pass a supplementary award within 30 days. That has to be straight. Section 64 will go on.
My lord, it would not inure to the benefit of the farmers.
No, but please understand that we have to decide the legal issue in accordance with law, not
Yes.
what benefits government, not benefits farmers. We can't. You make up your mind.
Long time, I let the order stay, my lord, because in the interest of the farmers, whatever little benefit comes,
Better.
let them take the benefit.
How much time, madam, authority, the order stands, how much time under authority will this thing? So we will say that you are giving up the challenge to your right.
For the present, my lord,
Ah.
for the present.
So what is this, Mr.? Our, no.
It's no point.
Learned senior counsel for landowners. Submission, his submission, modified so and so. Read, his submissions are recorded, no?
Senior counsel appearing on behalf of the respondent.
So therefore, this order stands now.
Throwing the challenge for the present, my lord, or the present, my lords may say, my lord, afterwards, my lord, unless if the proper compensation is not.
No, it's better than, Mister, this, all these things, giving up challenge, all you know, Mister, you are senior counsel, what are the legal difficulties with you? We can't do so. For the present, you either you withdraw, or don't withdraw. You will.
Present, my
No,
lord,
no.
said.
So if you withdraw, then you cannot subsequently file a petition saying that it has lapsed. Got it? There is a bar. So either
I will take it, my lord, I will take it.
There are only two options. Either you withdraw the challenge to this, that it has lapsed, and agree that 64 authority in a time-bound manner will decide. We admit the appeal. Choice is yours.
The farmers will be put to great inconvenience, my lord. if-
That is for you too. You are representing them. That's what we have recorded it. So then, how much time, madam? 3 months. Needless to state that the authority shall decide the claim of the landowners for compensation under the provisions of the Act in an expeditious manner. Preferably, you will adduce evidence, everything
Yes,
within a period of
3 months, my lord.
3 months from today. Thereafter, the amount of compensation should so determined shall be paid to respondents number 1 to 9 within a further period of 2 months.
Very well.
According to the aforesaid extent, line below, order passed by learned single judge is modified. Accordingly, appeal is disposed of. Thank you. Thank you. Yes. This was what? 4.
Yes,
This was
Delay
five.
of,
this is fine.
This is 5.
Delay of 86 days, my lord, preferring the
Ah.
appeal.
Yes.
Delay of 86 days, preferring the appeal.
Learned special GP heard on the IA 1 of 23, 2 of 23. The previous one which we disposed of was 4. Yes, 4. Madam. Madam. The other person took the dictation in item 3. You 4. You tell him to show me the order separately because sequencing this, I have told him I have doubts whether he has understood. So otherwise normal course it comes and we will sign. So ask him to separately hand it over to me at 1:30 so I go through. Yes.
may please the lordship, sir.
I am for the respondent.
My lord, appellants or respondent number 6 and 7, my lord, in the writ petition. My lord, writ was filed, my lord. My lord, writ was filed, my lord, seeking a, my lord,
Whether gift deed is valid, void, ab initio can be decided in a proceeding under Article 226. We will answer. Respect your ancestors who had gifted the land. What this for a public purpose? They were a noble soul. Respect your ancestors.
no, my lord.
You are fighting litigation.
No, no.
He must be pained somewhere. Let's see what he is doing.
My lord, but the appellant's grandfather has donated, my lord, 2 acres land, 2
Then
acres
don't-
land, my lord, wherein hospital has been constructed.
File a suit. All these questions cannot be gone into the writ petition.
My lord, your lordship may kindly say, my lord, no gift deed was filed, my lord, in spite of specific government being made in the count by
Gift
by
deed
me.
has been acted upon.
My lord, gift, your lordship, my
Gift
lord,
deed
gift-
must be in your possession.
Lord, your lordship-
Wherefrom they will produce.
my lord, your lordship, my lord, no, my lord, gift, your lordship may kindly say, my lord,
Chandrasekhar,
my lords.
late Rangamma had gifted the land for the purpose of construction of a bus stand.
No, my lord.
For the usage of, during her lifetime, there was no dispute raised. Now, only because over a period of time,
No.
everything has changed.
Value of land has
Well,
skyrocketed. The grandson visits the court and spends his rest of the time life in
Actually,
court.
my lord, the fact
No,
is,
no.
no, my lord,
We will allow you to be here. We will admit this, take it up after 25 years. You wait.
my lord, my
What
lord,
is your
it's-
age?
my lord, it's not like that, my lord. The fact is, my lord, what land was gifted, my lord, to HIPSRTC, because, my lord, your lordship may kindly see, my lord, what is the direction of the honorable single judge, my lord? The direction of the
Action is not to execute the gift deed.
No, my lord, your lordship may draw your lordship's attention.
Action is not to execute the gift deed.
Your lordship may kindly permit, my lord. Please number 38, my lord, single judge order. My lord, single judge says, my lord, in view of the same, liberty is granted to the petitioners to submit online application with respondent number 3. In terms of the said circular, with the request to mutate the name of the petitioner corporation in the revenue records in respect of the subject property and filing such application, he may consider. My lord, this fact is, my lord, the revenue records, my lord, in the revenue records, name has to be mutated.
We will also grant you the liberty to file a civil suit seeking injunction against them.
My lord, my humble submission is, my lord, what is the cause of action for me?
No,
I have the
cause of action is declaration of title. You are claiming to be the owner of the land. And file a suit. We in writ appeal, we will not declare your title.
Your lordship may see, my lord, particular passbooks are there in my name since 1988-89. Before that, my ancestors' name were there.
So-
my lord, then subsequently, my lord,
So what are your submissions now?
my humble submission is, my lord,
Number one.
my lord, the names of the, my lord, respondent corporation cannot be mutated, my lord, by virtue of section 2(6), my lord, of Telangana Rights and Patadar Passbooks Act 2020. Your lordship may kindly see.
Yes, we will see. Don't worry. Can't be, but we have to understand, right?
Yes,
You-
my lord.
With the moment we ask you a question, you start raising the voice. Nothing.
I am not.
It's a cordial. That's
I
the
think
thing.
I came closer to the mic. Sorry, it's not right.
Don't be agitated.
No, no, no.
We are only asking questions to understand the nature and
Yes.
purport. It's not that both of us are against you, nothing like that. So name of
Day and night, I saw my lord saying
Na-
that
name of
rights position cannot be decided in under 226.
you know it.
That is my that case, my lord.
Correct. Nobody
Cannot-
no. It shows from that learned single judge has held adjudicated the title between you and him, and then we will see.
Yes,
So first submission is that the name of respondent, which respondent? There are several respondent.
My lord,
You first said name of respondent can't be mutated in revenue records under section 6(2) of the act, correct?
yes, my lord. 1, 3, 1 to 3, my lord.
Respondent
No, no,
one,
2, my lord.
one
Respondent
and
one
two.
and-
Ah,
That's our,
That's
our
what.
action, my lord. Yes.
So that's why, see how, where the details are missing.
1 and
We don't know. You said respondents means all the respondent. Then
Other
second
respondents-
submission, second.
So submission, my lord. Then, my lord, the writ was filed, my lord, with the prayer to set aside the special tribunal order dated 22/6/2020. The writ was filed, my lord.
You filed
No, my lord. It is a corporation which filed the writ.
with R1 and R2.
R1 and R.
Say so.
Sorry. R1 and R2, my lord.
Filed WP.
WP, my lord, to set aside the, my lord, order of the special tribunal
Ah.
dated 22/6/2021.
22.
6/2021, my lord.
So
My lord, saying that, my lord, the special tribunal passed an order, my lord, saying that, my lord, that it is a civil dispute. The name of the corporation, that is, my lord, respondent 1 and 2 cannot be entered because there is a serious dispute of possession and title deed. So, my lord, they said, my lord, the special tribunal said, my lord, they have to approach the civil court.
so
Then, my lord,
Ah.
section 5 of, my lord, section 2, my lord, of 2020 Act
which 2020 act means
of,
which
my
act?
lord, the Telangana Rights in Land and Patadar Passbooks Act, my lord.
Ah.
Again, under
Section
this, section 2,
Ah.
6, my lord,
Ah.
defines, my lord, what is land. Land means, my lord, which is used or is capable of being used, the lordship got it, for purpose of agriculture, including horticulture, but does not include land used exclusively for non-agricultural purposes. So my humble submission is, my lord, under this process of this act, my lord, this land cannot be mutated in the name of respondent 1 and 2.
So single judge has not given a direction to mutate the name.
Yes,
No.
Your lordship has seen us.
Para 36, please
Yes,
see.
my lord.
Ah.
Earlier.
No, first of all, you finished your.
Yes.
So these are three submissions.
Then, my lord, section 5. No, my lord, section
Next.
5. Yes,
Ah.
section 5 of the same act, 2020 Act.
Mr. What is better now? What should you do? Type these 4 or 5 submissions. Just a minute. 5 submission, give it to us. We go through it in less than a minute. It is done. Now you are saying we are writing on the pad. Huh? How should you move faster?
Yes.
This is what it is.
the mid box.
There's nothing great about this, right? You could have done it 4, 5 points and give it us, passed on to us. Next.
Sorry, my lord. I'm sorry.
So that's what we are telling you, do it next time. So section,
Then section
for
5 of the-
submission.
Section 5 of the Act 2020, my lord, which says, my lord, registration and effecting change and record of rights when right over the land acquired by way of sale, gift, mortgage or exchange. Any person who intends to transfer or obtain an interest in land by way of sale, gift, mortgage or exchange under a registered document, it should be a registered document, my lord. If they want their names to be, the respondents 1 and 2, my lords, if they want their names to be recorded, my lord, or mutated in the revenue records, my lords,
So
then
we have
have
understood.
registered document.
Gift deed is not, gift deed is unregistered.
Unregistered. Then, my lord,
So
section 10, my lord.
one,
Sorry.
this for submission. Next.
My lord, the gift deed is not registered. Then, my lord, section 10 of the Act, my lord, 2020.
Fifth submission.
Yes, my lord. Case where Pattadar passbook come title deed is not so far issued. In their case, my lord, it's not so far issued.
And
To
not
any
issued.
reason-
Not issued.
To any reason, the Tahsildar shall issue Pattadar passbook, come title deed, duly following the procedure as in section 5. That is, my lord, which I have read to your lordship. Section 5 says,
Registered.
registered gift deed.
All right.
My lord, in this
Next
case, my lord,
submission.
registered gift deed.
That's it. Anything else?
Then, my lord, yes, my lord. Admittedly, my lord,
How many submissions? 5 and 6.
admittedly, my lord, is not-
Let me next submission.
Section 122 and 123 of transfer of property access, my lord. That it valid to constitute a valid gift deed, my lord, it should have been registered under section 17 of registration act.
Yeah, that we know. It's elementary, mister.
My
You
lord,
are telling, I mean, us about.
my lord,
gift
in
deed
fact,
is-
my lord, I have filed, my lord, I relate before the learned single judge also, my lord. I have filed before this honorable court also, my lord. A division, full bench judgment, my lord, which says, my lord, if a gift deed is not registered, that's on page number 247, my lord, the judgment of the full bench.
No, it doesn't require judgment of full bench. Gift deed has to be registered.
Then, my lord,
That is essentials of a valid this gift
Yes,
deed
sir.
itself.
1996 11 SSC also, my lord, filed Gomati Bai, my lord, wherein categorical said, my lord, until.
No, are we saying that gift deed is not required to be registered?
No, my lord.
Then why are you citing?
Because, my lord,
Wasting time when we said that gift deed is not required, is required to be registered, then don't cite decision.
very well, my lord.
It will come with cost of 10,000 each if you cite citation on a well settled proposition to which court is agreeing.
I'm glad, my lord, that.
Glad, don't be glad. This is not the word to be used in the.
Sorry, my lord.
Fine. Next.
Very well, my lord.
That
My lord, the patta stands in the name of, my lord, appellant's hearing from the year 1988-89.
yes.
The land has been converted into, my lord, non-agricultural land by the competent authority.
When
2019 itself, my lord.
when who is competent authority?
My lord,
What is the date of order? Don't don't refer to new facts which you have placed.
it was already pleaded.
Then
It was already stated in my
stated and document is there.
in my writ of appeal of
Fine.
also, my lord.
Yes.
Then, my lord, subsequently, my lord, it has been converted. My DTCP layout, my lord, has been granted. My lord, total extent of land is 16 acres, 16.5 acres.
How much is the area in
They are
this?
claiming 1 acre, my lord, 1 acre, which is
On which, according to you, on a residential layout is situate already there 1 acre.
Yes, my lord, it is-
And you are the owner of that 1 acre. Of
entire 16
1 acre residence, you have a residence over a 1 acre of plot.
16.5 acres of land, my lord, total land consists. Entire land, my lord, has been converted into non-agricultural land. Then DTCP layout has been approved. My lord, in fact, I have filed that proceedings also before the learned single judge and also, my lord, before the honorable court, my lords.
You are arguing the case on for purposes of admission, mister, not for final hearing, right? Huh? The moment we ask you questions, you argue this is for admission. Huh?
My humble
You want it to be decided today itself in
No.
the absence of other side, good.
No,
So
that's
what
not
else?
it.
So,
These are, my lord, my humble-
so 7 patta appellant's name land converted by for non-residential purposes when you don't know. Right.
2019, my lord.
You did not tell us who converted when, date of order, you did not tell us. So that's why you are saying you don't know. Next point, what is,
ATCP approval was granted, my lord.
so this is not a ground of challenge to the order of special tribunal, right? He has not quashed it on this.
In fact, it was not quashed, my lord.
Ah.
The learned judge had upheld the order of the tribunal, my lord.
Yes.
The learned judge has upheld the order of the tribunal.
And what is, so fine, got it, right? It has been, so therefore it is same submission that it is therefore not a land under the provisions of the act. It is converted for non-residential purposes. Therefore, it is not a land under as defined under section 2(1) of the act. Same
Tribunal-
submission.
Tribunal act order, my lord, is
So we are writing 1(7), so you will go on saying 25 submissions. Not done. You prepare us this thing and give it to us. It is not done. Ah. That's, yes. So let him finish. Yes.
my lord, the tribunal's order, my special tribunal's order is on page 55, my lord.
So what is your submission first?
My lord,
please?
the humble submission.
So,
my lord, there is
7
no-
submissions we have noted down. What else?
My lord, the order of the tribunal, special tribunal, my lord, neither erroneous, my lord, nor irregular. My lord, the special tribunal held, my lord, that, my lord, as there is serious dispute regarding possession and title, my lord, that the respondent 1 and 2 has to approach the civil court. In the case, my lord, they are claiming title and possession.
Yes.
The learned single judge, my lord, having agreed that, my lord, he said, my lord, pass an order, my lord, directing the authorities to record the name of the respondent 1 and 2, my lord, with the records, my lord, which is, my lord, per se not permissible, my lord, under the Act 2020.
Correct. That's it.
My lord,
That's it. Anything
the
else?
submission, my lord, as your lordship says, I would,
No, nothing. No, you argue. We have wasted, this much of, invested this much of time. Don't, argue after 3 weeks again afresh for 50 minutes. This is to be brought to logical
my
conclusion.
lord,
All we told you that you should perhaps bear in mind that you are not arguing the appeal finally.
the whole, my lord, the
Whatever. We are only ascertaining whether it's a case fit for admission.
my lord,
So there is a distinction. Scope of proceeding. That's what I said. That doesn't mean that you seek adjournment.
I am not seeking action. my lord.
Don't.
My lord,
It will not be adjourned for
I
that.
am not
Go
seeking
ahead.
action.
So what is the eighth submission? Now 9.
Panchinama relied, my lord, upon the learned single judges relied upon a Panchinama that is
Yes.
on page number 220, my lord.
Huh?
The page number 220, my lord, in the record. Panchinama.
Ah.
My lord, the Panchinama, my lord, doesn't say the name of the petitioner, the grandmother of the appellants. Is
What
wrong.
Panchanama? Handing over possession.
They say, my lord, position has been handed over. They say.
So when
But,
was
my lord,
the,
at that time
just
it
a
was
minute,
1988.
1 minute. According to respondents 1 and 2, when was gift deed executed?
My lord, according to them, it was executed in the year 1988.
When?
But no, for
When?
gift deed is not filed anywhere, my lords. That's a
Date is also not known.
My lord,
Date of execution of gift deed is also not known, right? And what was your age in, just a minute. It was executed by your grandfather,
grandmother.
mother. What was your age in 1988?
21, 22, my lord.
So what you had this thing, what it was a property of your grandmother, right?
Yes, sir.
So why your signature ought to have been taken on the Panchanama? What capacity?
Not my signature.
You said it does not mention the name of petitioner.
Appellant, sorry, my lord, grandmother of appellants. That properly. The wrong name has been prescribed.
What else? That means possession was not handed over.
Yes, my lord.
Or
And no, my lord, the proceedings of the competent authorities.
any civil suit with regard to title is pending?
No, my lord, it's not.
No seal.
My lord, in fact, my lord, the proceedings of Tahsildar, my lords, which are filed before your
Fine.
lordship.
What else?
My lord, it says, my lord, that no bus station was constructed, never.
No, so this was your 9th submission about Panchanama, 10th submission.
Panchanama is, my lord.
Then what is the next 10th submission?
The proceedings of my lord of Tahsildar, clearly, my lord, which
No,
have
don't,
filed.
Mr. Don't convert every sentence into a submission, right? Submission has something to mean. You understand the concept of submission. Don't say every sentence as a submission.
My lord, my humble submission is, my lord, relying upon that Panchanama, my lord, the learned judge, my lord, directing, my lord, to mutate the names of the respondent 1 and 2, my lord, in the revenue records is not impermissible.
All
And my lord, it is nothing but, my lord, it amounts to foul play where they don't have a title, my lord, they want to get a title by, my lord, by virtue of this.
Acha. So this order, according to you, decides the title of respondents 1 and 2.
Asking to enter the name of the revenue.
What happens revenue, entry of revenue record,
My lord,
what is the effect in law?
by virtue of that, my lord, title. What they have done, my lord, already, my lord,
So, sir,
because, my lord, it's a
So what
corporation.
is,
They're
Mr.
trying to,
1 minute. And submission is order passed by learned single judge decides the title, declares R1 and R2 as owners. Right.
not one,
Ah.
my lord. My lord, it is,
This is submission, right? In
Lord,
11th submission.
by virtue of that, my lord, they are trying to, my lord, interfere into my possession and flying the buses in the, my lord, my land, the appellant's land.
On your house.
Not house, my lord, it's in a vacant land, my lord, it was converted into plots and sold to, my lord, third party.
What is
BTCP approval is there.
fine? What is
My lord, my humble submission is, my lord,
Ah.
this order may not sustain, my lord, in view of the, my lord, as it is against the, my lord, law and the facts of the case, my lord.
what against law?
My lord, I have read, my lord, the section,
Ah.
provisions of Act 2020.
That we will answer.
Instead, it is not valid.
That
As
we
per the
will.
law and as per the statute.
Fine.
My lord, can, my lord, an order be passed, my lord, my humble submission, can an order be passed, my lord, against the statute and the.
No, don't ask us question.
My lord, my humble
Can this
submission.
be passed?
Why, sir?
Don't. We are not sitting here to answer our whatever order we will pass. You can go to Delhi. If we don't know. Yes, madam. Heard on the question of admission. Please sit down.
Biplab,
You have done well, argued very well. Whatever the result, right? But you argued well, correct? That's how it should be. That's how it should be. In this intra-court appeal, this intra Let's see. It is well settled in law where I've said that. You, first para, you did take it, well settled. Huh? Huh? So this sentence you, madam, this substitute here. Complete. That. Yes, next.
Please, your lordship, sir.
Yeah.
So,
Huh?
Commissioner appointed in the year 2021. Yes.
Heard on the question of admission notice. Next.
Millet. The petitions before your lordship.
Huh?
I have obtained environmental clearance and a forest clearance for the purpose of.
No, one this thing, one query before you go ahead.
Yes.
Can you file a writ petitions, seeking a writ from this court to for enforcement of order passed by NGT?
Millet, years person.
Answer.
Under section 22 of the
No, NGT has no power to enforce its order.
Section 25 and 26 separate of NGT Act,
Which act?
the National Green Tribunal Act 2010. But section 25 and 26, 25 says not execution of the award or order or decision of tribunal.
that is.
An order of a decision
Yes,
of the
there
tribunal.
is a
25 is execution, 25 is the penalty.
So 25 execution, NGT's
Yes, Milord.
has power.
As regards civil penalty, an award, an order or decision of the tribunal under the act shall be executable by the tribunal as a decree of the same court.
Fine. Got it.
It's true, man.
Page 25, prayer clause first, then you ask.
It's true, Millet. It
Para 25, page 25.
Yes. Prayer I sought for is pursuant to the
Read.
in view of the above mentioned facts and circumstances, it is therefore prayed that this honorable court may be pleased to issue a writ or direction, more particularly one in the nature of the writ of mandamus, declaring the action of the respondent.
Mandamus, when can be declared? Mandamus is issued to declare.
Declare in procrastinating.
Mandamus, performance of a statutory duty.
Yes,
Not mandamus declaring action of so and so. This is all wrong, mister.
in procrastinating. Say,
Read.
yes. In procrastinating in examining the recommendations of the EAC, Expert Appraisal Committee during so and so 30th EAC meeting, and not in complying with the direction issued by the respondent number 1 through its judgment dated 39/2022 in appeal number so and so. Being aware of the timeline of 9 months as stipulated in the order dated 39/2022 with an ill motive to halt the project envisaged by the petitioners arbitrary. Here is the action which Malat
No, read.
arbitrary, unlawful, illegal and contrary to the public interest, contrary to the environmental laws, contrary to the public policy and against the interest of public at large, and consequently may permit the petitioner to commission the project forthwith without causing any further delay in view of the complaints of the direction given by the Honorable National Green Tribunal through its judgment dated 39/2022 by the petitioner duly considering the acute shortage of power generation in the stage of Telangana as well as in the interest of the public at large and pass such an order for deemed fitted. But here is
So as we understand, the prayer is so long you have read.
yes.
It would have been better if you would have said 1, 2, 3. It
Yes.
would have been easy to this all clubbed together, half page prayer and substance we get it. It is for implementation of judgment dated 30th/9/2022 passed by the National Green Tribunal.
Yes.
So the short query is the NGT has power to execute its order and decision under section 25. So why you should not take recourse to section 25 and file a petition here.
Yes,
We are not an executing court
I cannot.
seeking implementation of directions of given by NGT.
Yes, this is a court order. Can
Yeah,
it-
otherwise you delete this prayer and then what survives we will examine because it is incomprehensible. What
That-
you have half a page without full comma, full stop, running and that's why the purpose, you are a senior counsel that we are every petition, Mr. Counsel, we take this opportunity, every petition, these prayers are drafted. It's difficult to comprehend what you are this thing and half a page without, wouldn't it be better therefore pray following number 1, number 2, number 3 so that anybody who reads knows like at a time 1, 2, 3 how many lines we don't know, you want us to read continuously without break. So this is mandamus. This is what you are seeking, that judgment dated 30th/9/2022 passed by NGT be implemented. We are asking you to go to NGT itself under section 25.
But the judgment, full bench judgment,
What judgment?
2023 live.
No, what is it, Mr.?
Virat, the maintain, just to go before Virat.
They see, so say so that there is a judgment on this point saying that he should go before NGT.
That
What do you do, Mr.?
here, just I would like to bring certain aspects of law before your lordship. Here is a case,
Second page.
here is
One
a
minute.
case,
1 minute.
Second page, there are 4.
Full bench? No, Supreme Court, Mr.
Supreme Court. There are 4 advertisements.
Same order.
I got,
We will,
yes,
we will dispose of
yes,
your
you know, your lordship may
petition.
kindly.
Same in terms of judgment
But
of
section
Supreme Court.
25, this NGT Act clearly says that the entity is endowed with the power to execute the order passed by itself.
What are you arguing? That's what we told you.
Yes, I'm just coming to the point. But this is, it's not only an execution of the order passed by the
Let's amend the prayer clause then. Delete this thing, that implementation part. We will see what survives in your petition. Amen. Correct. Will you amend? Will you amend?
Just I will amend, but just
Fine.
before that, just I will submit.
Amend.
Very few facts and let me submit by that. These, not only the order passed by the.
Then we will not permit
But
you to amend.
that's it.
Mr. Please, senior counsel, if you argue, then it's all right. Then we will decide it. Go ahead. Then only there is point. We will hear you on merits. We thought that you are a reasonable person and you understand that the substance prayer is to implement the judgment dated 30th September 2022. If that is so, you have to take recourse to 25. You are trying to tell us in addition to 30th to 2022, I have claimed several other reliefs. Okay? If that is so, delete this implementation from this prayer clause and then we will consider what survives our consideration in this writ petition. So far as this relief clause is concerned, seeking implementation of 30th/9, Supreme Court has said that the party must approach the NGT under section 25. It is either we dispose of in the light of Supreme Court to asking you to go to NGT under section 25 and tribunal shall consider the application, what steps should be taken to ensure its directions, or you argue or amend. These are the options.
I leave it.
Brief facts means
We will
what
go.
facts?
Under section 25, we will go.
This is what we meant. Mark the presence in this writ petition. Yes. Item 9.
Notes వచ్చింది. Batch is there, no?
Ah. Over. So my petition is admitted for hearing. Notice. We have admitted for hearing. Admitted for hearing. Yes. List along with what is the number? Many a time this wrong numbers are given. Please give a slip. All right. Same order 10 admitted for hearing, list along with WP 21192/23. Any admission made against the NCC quota seat shall be subject to outcome of the writ petition. Any admission made against NCC A and B category.
A and C totally neglected. Any admission pertaining to NCC, that will be start first.
That's what we said. Okay. You said A, B, we said NCC category.
Okay.
NCC category seats in MBBS and BDS course.
Yes.
Shall be subject to outcome of the writ petition.
Apply.
Lord, I think we permitted to withdraw the petition.
Huh?
026
Notice. Heard on the question of admission, admit notice.
Lord. Similar matter, Lord, I have an objection.
Dismissed. Similar matter dismissed.
Not that, Lord.
Then we are directing issuance of notice.
The same relief, 2017 writ petition is pending, filed by same person, and he wanted to withdraw the writ petition. This writ petition he wanted to withdraw.
You said you want to withdraw. Then why you did not say? You should have said, I want to withdraw. We said admit, you didn't say anything. Not Mr. Learned counsel for the petitioner seeks leave of this court to withdraw the, which case? 12, 11?
11.
12.
11, my lord.
Learned counsel for the petitioner seeks leave of this court. Yes. Yes. Next.
May please.
This batch, yes, batch matters are earning 100% 85.
Heard on the question of admission. Petition is admitted for hearing. Notice whosoever accepts, Madam, right.
Lord,
Yes.
The other matters are posted tomorrow, my lord.
What
Even
can
this-
be done?
Lord,
List
UG,
along with WP number. This is
UG, you issued in respect of UG admissions. This is PG admissions.
PG admission. So different, right? Why to sell with UG?
Aspect remains the same. 100%
No, you
reservation.
want to rely on that. Don't want to argue your case.
I appeared in one of the UG matter. Tomorrow they are listed.
Okay, Mr. Do you suggest that we can decide this next 24 hours petition? Your petition is listed today. It's coming, it has been admitted. They have to be given time to file counter. What do you think we will allow it tomorrow? And they will file response within next 24 hours. And
I'm asking the same relief, my lord, to be extended to these petitioners. The
don't
UG
delete admission list along with WP number.
My lord, I'll give the numbers.
We will admit it tomorrow then, that's it. This
Similar orders passed, I've annexed to the.
Where is that?
Yes,
Which page?
Page 32, my lord. This is in respect of UG admission,
32.
page 32.
So that's what you should say first, right?
Yes,
So UG, so
Yes.
what difference does it make?
100% reservation for the same. Geo
No,
number.
so you have been registered for the PG course.
I registered, counseling is yet to commence, my lord. It will commence in a day or two. Tomorrow, yeah.
This is not this thing. It's for, you are already registered, so no interim relief is required.
Registration is different, my lord. Counseling, opting of, my lord, the branches.
Read the order, page 37, which you are relying, Mr.
32, yes.
Attend the application.
37. What does this say?
Registration for admission.
That's why we asked you that if you are already registered, then there is no
Petitioners
need.
are registered.
So
Counseling is, my lord, to be commenced tomorrow or day after. So I need to fill up the options for that counseling.
list along with WP number. We are not passing any order because you are saying that it is tomorrow. List along with WP number.
18047 of 2020.
I'll
Yes.
give the numbers.
GP for revenue there.
Yes.
Short point, my lord, by way of public interest litigation, but one Kombaravati Devasthanam, my lord,
Heard on the question of admission notice.
deeply aware.
Admitted for hearing notice.
And for some time,
Matters will come.
They will have to file a counter and all.
Item 14, letter GP for.
You say notice on admin, notice before admission, not admitted. Yes. The grievance in this letter petition addressed. The grievance in this this writ petition has been registered on the basis of a communication dated 29/7/2023 addressed to this court. Full stop. The grievance of the petitioner is that and report compliance. Where is the question of contesting such sort of claims? We are asking you.
Yesterday we have forwarded the file, my lord. Now they have already they are conducting
Learned.
inspection today, my lord. We'll file it in-
Learn it. That's what.
Yes.
Learn it. Standing count. Yes. No. This public interest litigation has been registered on the basis of a news item published in Times of India, English Delhi Hyderabad City edition, wherein a news item was reported stating that in a horrific incident, class 2, a young girl aged about 8 years of a young student aged about 8 years, class 2 student of Delhi Public School, Bomrapet, namely G. Dikshita, was crushed to death by a speeding private school bus while the girl was on way to the school with her father. The accident occurred near Dr. Reddy's lab, Bachupalli, uh, due to what? Due to a pothole on the road. Full stop.
One respectful submission, Bachupalli comes under Nizampet Municipal Corporation.
Whatever.
GHMC is made a party, it may be also be included.
No. So the potholes of every city, right?
Bachupalli is some different municipality, municipal corporation.
Mr. This public interest.
Potholes in municipal GHMC limits.
No potholes. We will record your statement and appoint panel of senior counsels to give us a report
For better
and take action. This is public interest litigation. Please understand. The grievance, if it is entertained, is not confined to that DPS school, and you will show that I have filled up. It will be closed.
Nizampet Municipal Corporation.
It is these citizens of in twin cities of Hyderabad and Secunderabad, several potholes exist on the road, due to which the commuters find it very difficult
Please. Last occasion, Lordship has pleased to condone the delay of the order. The challenge.
Because there is a challenge to this proposal in one of the restrictions.
So this amount recovered from you falls within the purview of clause 18.4 of the agreement.
What I claim, Your Lordship. Yes, yes.
18.4 of the agreement.
Yes.
Yes. Heard on the question of admission. The appeal is admitted.
Will be completing today.
Oh, acha.
They have served alert.
Served also. You are ready?
Ready.
Then at the end of, please wait then. Let us finish, because we don't want to keep everybody else waiting.
Oh, sure.
Right? He is an outstation. You are ready?
Yes.
Then we'll decide if necessary. You are ready, Mr. Or you take up this thing?
No.
We are prima facie inclined to accept. That's why we have without.
I will be completing. All right.
Yes.
Same matter, similar.
Ah,
matter you
similar.
had come. There is similar matter you had come last week on which same challenge to DM.
All right, all right. At the end of motion hearing, please come.
Please, my lord.
70.
70.
Ah, yes.
May I please, my lord. The petition 7932 by 2023, petition 267 by 2023. And review petition.
What is the prayer?
My lord,
Prayer in the petition.
my lord, to club is three repetitions.
You are a judicial, Mr. You are a judicial.
My lord, if-
Well, listen to us. Listen to us. You are a judicial officer. You know what is done to club a petition. What should you not move? Registrar judicial. Do you not move an application in those? How an independent writ petition?
Lord,
The prayer is that no. Please tell us. No. Please read the prayer clause. Then go ahead. What is the prayer? Read in the.
from my uh, application of the representation dated 25/3/2023.
That's why we ask you. You probably don't know what is the prayer sought. Please read the prayer aloud. This thing in the petition which is sought by you. Read it. What do you want? You don't know what do you want. That's the difficulty.
No, my,
Once.
because
Cases. 14 bedroom possible.
Yeah.
Can give you judicial.
Yes, read. Which page?
page number 4,
14.
4.
Ah, yes.
These to issue an appropriate order or directive, both particularly one of which of because of my representation dated 1/5/2023, filed before the Honorable High Court of Telangana by the petition 17371 by 7932 by 2023. Review petition 1/153.
Speak into the mic. You're not.
And review petition 1 by 2023 in writ petition 7288 by 2022 together to be dealt by the full court of the Honorable High Court Telangana, consisting of 7 to 11 judges headed by my Lord Chief Justice, as fraud is being played on the Honorable High Court by the vested interests, resulting great injustice is caused to the petitioner, resulting compulsory retirement for no fault of him, and pass such other order or orders as this honorable court may deem fit and proper in the circumstance of the case.
So, Mr. What happens? You are a judicial officer, right?
Maybe.
You are a judicial officer. What happens? Can you seek a writ of mandamus or by filing a writ? You file 4 petitions, right, for different this thing. And can you seek a writ of mandamus that all 4 petitions should be clubbed together and should be decided by 9 judges of this court?
No, my lord.
This
If
is
this honorable
again read
that's
there.
why my lord, the Chief Justice,
Again read. In that bench, Mr. Just a minute.
together, I
This-
may get justice, my lord. That is that.
No, we are doing that.
Bring the said fact before your lordship with a fond hope that I may get justice, my lord.
No, we are doing justice to only. According to you, no, Mister, according to you, you have a preconceived notion of justice that all your writ petition should be allowed, all respondents should be hanged to death. Then only justice is done. This is not so. Please tell us what sort of a prayer this is, and how can this be in that writ petition? Those writ petitions you have to make you have to make an application for linking together. That bench will take a call. If that bench is unable to take the call, they will place it before registrar judicial. I will pass an order on administrative side whether accepting your prayer for clubbing or this thing. No separate writ petition is filed. You cannot if the matter comes before a judge, the bench dealing with your writ petition, there you have to convince them by saying that this matter requires to be referred for consideration of a larger bench because of the issue involved therein. So you have to convince the judge before whom this thing, no separate writ petition lies directing constitution of 9 judge bench, 11 judge bench,
My lord,
and probably you should have said two.
or, or before uh, different courts.
So therefore you are, therefore you are,
To avoid conflict.
therefore we are telling you as a judicial officer, you are a judicial officer, part of the system. Therefore we are telling you, your remedy lies to move an application to the registrar judicial on administrative side. That application will be placed before the chief justice. He will decide on administrative side. This is not the remedy of filing a writ petition. We will dismiss it then.
No.
Argue then, argue.
My lord,
Why?
I implore your good sir. Already I filed a representation before the registrar or
Where is the representation?
25-3, my lord.
16 to
This is,
Already filed an application.
this has to be placed before me on administrative side, mister. Please understand, I will deal with it on administrative side, not a writ petition. You withdraw. We will take up. Yes, it is, you, all right. Learned counsel for the party in person submits. Correct.
Much of pleasure.
Don't file this sort of petitions, mister.
Matter on the last occasion. Your lordship,
What? No consensus?
no, your lordship, just, I'm appearing for the SBI, just now I got the wakalat, your lordship, I file it in the registry. A short date may be given, I'll file my
When?
matter also.
Which?
Just now I received the
Arey,
wakalat.
what date? We understood. That doesn't mean you should repeat. We are not hard of hearing. How much time you want to file counter that? He said, no, senior counsel said, okay. So you should have said that 1 week I'll file counter. Learned counsel for State Bank of it. What? Which respondent? Again, respondent number 2 submits that. You don't know which respondent you are appearing.
I had to take paper.
Learned counsel for respondent number 2 submits that. That 25th is a holiday.
28.
28th is 28th. Yes.
Much of it.
Yes, sir.
Huh.
Your Lordship.
No, come here. You are, don't appear with the state government. Huh? You are a petitioner. You are the person who doesn't know that case is listed. Huh? So what do you say? Are you aware about the order dated 6th of July 23? No, no. Are you aware? 6th July. Show it to him.
Lordship, advisor,
Read it. Read it.
I'm going through the webpage.
No, read it aloud. Read it.
Head Mr. Srinivas Kuncharam, petition person. I'm going through the amendments made in writ of remit. And after the hearing him, as well as considering the office objection, we are prima facie of the view that there is no substance in this public interest litigation for our interference. However, we grant liberty to petitioner to examine this aspect and make submissions in the next date. Sir, I submitted a representation.
Return the order sheet. So we just wanted to tell you, get the order sheet.
Sure.
So are you ready?
Sir,
Are you ready?
Yes, I'm ready.
It's our record. We only wanted to apprise you that you have to argue in this context. Fine.
Your
So
Lordship,
what is the prayer in the petition? Please read it aloud. We have not read it.
because of the bill, sir, the petition saying that election expenditure is.
No, you are what? You are an advocate.
I'm GitHub NGO, sir.
Huh?
GitHub NGO. My NGO is GitHub.
You are not an advocate.
Really, of course, I'm advocate, but I'm here parting person.
So what is the prayer 35? Read. Final pray. Final praise, it says 35.
Pray is that, sir?
No, final pray. It's it's not PREY. It's AY. We heaved a sigh of relief.
Prayer actually.
Final pray. Final pray, read. Final pray. Read. Final pray.
Through this bill, in the interest of real democracy, hence the bill is more seeking writ of mandamus, order, direction, opinion of the respondents, in particular election commission and other appropriate in the best interest to uphold the process of electioneering to fall into playfield of overclass, kleptocrats, exclusive zone, at least applicable the ensuing general elections 23 states assemblies in nation, including Telangana state and parliament, general elections for lower house in 2024, and even thereafter set so democratic entities. Second, please, sir, second amendment. Necessary amendments to RPA 951, thereon procedure change. Expenditure scrutiny shall precede the counting of votes. I'm asking the expenditure scrutiny is beyond 30 days after return candidate. So there's no making postmortem exercise, anything, but I'm asking the process between two terminals.
No. So you have read it. What? Anything else?
Expenditure returns verifiable. Just like VDPT, to whom I voted, let him immediately know whom, just like ERBT as the expenditure made by the candidate.
No.
Right.
This lecture afterwards. First read the prayer. Expert comments thereafter.
Expenditure return variable. Say ERBT, just like VBPH part, to get as sword, having disqualification invariably on those caused violators next 5 years, not 3 years, or at least to the next term of elections. The violators has to be not to be permitted for the next elections. What happens?
So did you approach with it?
To time limit for filling as the vacancies, particular state of legislature and central houses parliament, the under section 150A, 151A, the remainder of the term of member in relation to vacancy is less than not 1 year, 2 years, because nowadays they are playing with this 1 year's job. They become a egocentric process. Fourth, to disqualify the candidate who resigned the existing seat, for litmus test, are a self-centric, egoistic, artificial reasons before 1 or 2 years. Not be eligible for the vacancy from any party, even previous party person simply vacating for elections.
Yes. Therefore, we have now read. These are your prayers.
So, sir.
So 2-3 questions we will ask.
Yes, sir.
have you approached with regard to your grievance to who conducts election in our country? High Court?
Sir,
No, who conducts? Please answer.
Election Commission,
Election Commission of India,
24,
right?
article.
So Election Commission of India conducts the election in our country so far as parliamentary elections are concerned and elect. So they this thing, right? They conduct the elections. So High Court definitely doesn't conduct elections. You agree that the High Court does not conduct elections. So all your grievances are with regard to elections which are conducted by Election Commission of India. Just a minute. So have you approached with regard to your grievance to Election Commission of India?
Sir, as previously, our Honorable CJ advised me to approach the ECA.
That's what we are saying.
I went there, sir. I submitted the copy also with me.
When?
I submitted, sir.
No, he did not advise. The order doesn't say.
Concern section.
No. What is not in the order, we will not. The order does not say that we advise the petitioner to move election.
Only.
No. We since you are an advocate, that's why we have asked you. Otherwise, it is none of our business. We will dismiss the petition by saying that go to Election Commission.
Yes, sir.
Fine, go ahead. So I argue, we are not advising anything to you. Please, we don't want you to say this about us that we advised you.
Sir,
To argue.
Curtain of election petition, election is there, sir.
These directions you want before the dates. Just a minute. Listen to us. All said and done, Mr. You should realize what will matter is what we write, not what you speak. Okay. Therefore, you will have to listen to us. You are not here to give a speech to us. Somewhere that you go to bar association, ask your fellow colleagues to listen to you, they give a speech. This is not a place for a speech. What we write matters, what you speak doesn't. Please appreciate it. Therefore, you have to be.
Please.
All right. So all these elections you want in directions you want in anticipation when the dates of elections of 2023 have not been notified. Right? And what is the cause of action for you to file this petition?
The cause of action, sir,
Yes, please answer.
sir, when I went to the
First, when did you approach Election Commission of India?
first, sir, it's the CEO of the concerned Telangana State, CEO office, Chief Election Commission.
Election Commission of India.
India didn't go, sir, because I didn't approach to India. Next time I'm planning to go, sir, this week, because
First you approach, bring your grievances to the notice of Election Commission of India.
ECI, nothing but, sir.
I will not agree. Please argue.
The purpose is, sir, the ECI is nothing but option, next to the delegated election duty. Already they are going the job. They have submitted a copy to ECI. Please bring the matter to the concerned parliament or to the head of the ECI also, sir. They have taken my plea and asked them to this matter pending with the Honorable High Court. So the plea is this, sir, here, having judicial powers to, because the constitutional court, this constitutional court, Supreme Court and High Court, have empowered to direct mandamus or even opinion given, because this is a sensible issue, sir. Election became a mockery for the whole class. Just what's kept out a vote buying system. See, the election RPS says section 773 says you have to put some maximum limit, 40 lakhs something, and for the parliament 75 lakhs and 95 lakhs. Sorry. See, this 40 lakhs in this scrutiny is going on after 30 days. The person elected and to the enjoy the privileges of the honorable MP and MLA and ministers also election. The matter goes up to 1 year. Even High Court can give more extra time also for 1 year. And the reason is as observed, the Election Commission has given 1 year to settle the accounts. I show you the what they have given. So 1 year, Delbert accepted. So election after 1 year. Who knows what happens 1 year? Subsequent should not subvert the main process. The process is between the two lines. What I say, present with election notification, the Election Commission can empower everything. They conduct the elections in process. Only thing the T29 says that not to be interlocutory
you are asking us to adjudicate without going to Election Commission of India, right? We will decide it.
Even PCS, and please, Truthfully, I think copy will goes to the concern
Fine.
planning council.
No, and if we adjudicate about your averments, nothing will survive.
Sir, I will go
Fine.
sir, to.
Then you withdraw.
I'm approaching, sir. Anyway, I'm going next week. So next week,
It will not be like you will go to,
last time,
no, you will go to see the India House and like India Gate and we will keep the petition pending. Nothing. Sorry.
I will go to, sir.
Either you, Mr., we are giving you two
Democracy, sir,
options.
democracy.
No.
Democracy has sustained, sir.
We-
I will give, sir. What is
Mr.
the, sir, what is the will of,
We are respecting your age. Two options. Two options. Either you withdraw this petition and with regard to your grievances to Election Commission of India or competent authority, number one. Second option is you argue, we pass and on. Choice is yours.
because
Please.
the remedy is
Please.
always just going on.
Fine. Fine.
I'm arguing, sir, the election, we are both having an obligation. I will show the sanctions of the obligation. The terms of the, because they are, sir, a constitutional courts has to, if they don't take the 8 at time, who cares, sir? Election is nothing but purity of election, election purity is bedrock of the election, sir, as per the 773 says that, it's saying that the objectivity is that level playing field. What is the level playing field here? Class people simply vote buying system, liquor distribution, muscle power. See, it become a demonstration of the elections. So I believe that the court has to come to the please and how the already the questions of RPA says that you have to apply the 47(1)(3) section A, 77 article 1 and 773 also, sir. Plus some caps some there. Nobody is following. One thing, sir, here election commission given is a expenditure is acceptable and non acceptable. See, comparing all this, okay, we'll accept it. But vote buying and liquor distribution is irrelevant. So the so-called papers, Hindu paper, all papers given to 500 crores have been expired in the one elections. Example I given, not bad the people only party for. Thing is that the election commissions have submitted report as 28 lakhs. Nobody has posted the 40 lakhs even. But I of course, what is the SOR given the reports I submit you. See, 3 members, even the so-called papers, Hindu, every media has witnessed for this, sir. 500 crores expanded. But see, the Hindu paper is reporting wrongly, the other paper reporting wrongly. Simply, the election commission has given having all the instrumentalities, the price squads, TMT, Q sheets, everything. Now they are going to 20, they want to having all the. My submission, sir, the election commission not at all having to the obligation 324 says that you shall be supervised, direct, SBCC, direct, and control and conduct. 324 given a full power to the EC. Once the election has the notification given by the President of India, and everything will be come to the on the control of the EC. And EC can even call the President or even also, sir, that power is given for EC. So it's simply keeping quiet. Even 38 lakhs only. 40 lakhs is not at all passed. Nothing but 5 lakhs situation. And everything has evidence. I will also, I myself made a tour also. I went to Manohar, sir. Simply, see, liquor shops, I don't want to say before this become not witness, but I'm also reporting. As a citizen of NGO, I give a type of placards. Take liquor not to sell out your work.
This is not about liquor, this is about the reliefs. That's why he asked you.
So everything comes under expenditure.
There is no.
What is sir? Scrutiny. Policy is there, sir. Definitely, I put up my hat. I mean, what am I? So if policy is there. See, the election expense should be before between the lines. What I'm telling, not after the lines. Between the lines, the election should be between the lines. At least the principle. Sir, tomorrow you have to submit your election dates and all the box of all the day, and then it will be scrutinized by the committee. Committee is having. Sir, you said I was a don't go, sir, because I execute NPDO. Sir, I was saying I work with the flying squad team also. I'm head of the flying squad. The flying squads, TT teams, standing teams, and VVT, video team, everything they will put every day sharp. What is happening and supposed to is maintenance every candidate is everyday expenditure and expense SOR standard observation report and the so-called observer, like election observer comes to 3 times only. Before the last date, he will do something. What happened here? Exactly the 20th class, nobody crossed it. Simply that certificate, the time and manner, somebody asking. And I mean, sir, I have to submit the vouchers report. No matter it, because simply you are given 28 lakhs now, sir. What does it submit the vouchers? Simply, I see the things were there, they have submit. IT is submit everything, even though not IT, the person has submit the IT returns. Because not having IT also have submit. And the peculiar about the IT, not why the democracy is by in vain, and nobody is following this so-called and law makers to be aware to our law violence will be sitting in the legislative bodies and become law makers. So can we search the high courts and the Supreme Courts? Can we say if there is a provision is there? Why not you scrupulously maintain it? Expenditure scrutiny. Ask before the sir, I'm asking one please, sir. Ask before the cart, not after the cart.
I have to stop now.
The expenses scrutiny should be between the lines of the election process. Process started by the
Your entire writ petition, 1 second, your entire writ petition, reading of your entire writ petition indicates you are so obsessed with Munugodu by-election.
Yes.
Only that is the only. No, but about that you have not approached any authority.
Sir,
Straight away came to High Court.
that means easy, sir. That
Whatever it is, whichever authority, you have not gone anywhere, you have straight away came to High Court.
last year I went there, sir. I submitted a report to him. Last year, those days, easy has gone away. Easy has complete by 1 month only, sir.
Pending 20.
And since they will do some consolidated report and simply put the ban, sir. So what happened here? I could not able to get an opportunity to meet the ECI. Last week I met.
That's it. Anything else?
Please, submission, sir. Please think over, sir, because it's a constitutional body. Court, sir.
Fine.
The people doing the mockery of the election, sir.
Fine.
So could we avoid the elections coming for 5 states for
Fine.
next year, this year, including Telangana also. And
Fine.
next year, the election for
You have been heard once on 6/7/23. Again, you are arguing same thing, right? You have been heard on 6 July. We showed you the order in the beginning. Fine. Anything else?
This is our submission, sir.
Fine.
Plain, sir.
In this-
the elections to be
Fine.
continued to the honorable court, open is given to the concerned stakeholders.
That's it.
Including the parliament which is going on now.
Fine. Thank you. In this.
Sir, can I submit the
petitioner- No,
These are the
no.
books I bought for you, sir.
You have argued the petitioner has,
Scrutiny.
the petitioner Next. Cordless. 20.
Or, sir,
20, yes. Yes. Mark is a presence also. Praveen Kumar. Mr. Another PIL on the same subject matter. Huh?
This is regarding inaction of my representation on 16/8/2022. Page number.
No. Legal approach.
Page number 37.
I have got this.
No action is taken by the
Another
restaurants, my lords. That's I have to approve this honorable court. As per the gazette, it's a work land, my lordship, and as per the joint survey of revenue and work code, it's treated as a work land.
Another writ petition on the same subject matter. See. How PIL is. Do you know, Mr. that petitioner has earlier filed another PIL through another council on same subject matter? That's why.
That was disposed of. That petition was disposed of.
Did you disclose it? Have you disclosed this fact in the petition?
Yes, my lordship, we have mentioned the PIL number. You have mentioned here.
Where is the order passed in that PIL?
Page number 8, my lordship. PIL 286 of 2020.
No, where is the order passed in PIL?
That order we have not enclosed.
That you should enclose. Come clean. Otherwise, we will dismiss with. You will forget work land. You will have to. We will direct recovery of cost from you. You will forget work land. Work land you will not get. And filing this thing, repeated petitions. What should the writ petitioner do? He must approach the court with clean hands. Are you doing so with clean hands?
We have mentioned the
Not
PIL number type.
No.
Type may be granted to file before this honorable the next year.
in view of not mentioned PIL number.
We have not mentioned. That's a wrong statement you made.
Page number 8.
No, Mr. All this is being taken note of. We are watching your conduct. That you are making a false statement, suppress the factum of earlier petition and this thing, not annex the copy.
Just copy we have not done, right? We will next my lordship, time is granted.
The office has raised an objection. What happened to 20?
So 21 is urgent.
20, what happened just now? 20. Okay, yes, now 22. Yes. What happened?
Well, in this matter, since Mr. Raghuram came into the picture, both parties are sitting down for a discussion to give it all a quietus.
Yes.
But in the meanwhile, your lordship may have to assist us by ensuring.
There, then we will have to
He's there and he's representing Mr. Raghuram here. Yeah, he's here.
You should be here, right? Along with we are looking.
Our bar is constantly testing your lordship's eye contact.
That's what.
We are ready for dialogue.
So then,
So your lordship may see that the passport is not compounded. Keep that order in suspension for a period of 4 weeks.
Correct.
And post it after 4 weeks.
yes. So how much time do you want?
4 weeks, my lords.
4 weeks.
4 weeks.
Learned Counsel, Senior Counsel, Mr. L. Ravichandar, Learned Senior Counsel, as well as your Mr. Sri P. Raghuram, Learned Counsel for responding. Yes. Rejoinder, somebody had to file. Rejoinder you want to file.
No, you want to file rejoinder, it is coming for rejoinder.
Counter has been filed yesterday, right?
No, my lord, earlier. R2, I appear for the R3 for filing rejoinder last week.
How much time? Learned counsel for petitioner preference granted 3 weeks time to enable him to file rejoinder. Next.
Please, I'm appearing for petitioner. The petition is filed by the state, not the forest department, not the against the, not the orders of the HRC.
I am for the respondents, my lord. One submission I want to make, ma, before beginning the arguments. The last occasion, my lord, the learned GP reported that pleadings are completed. Now, yesterday they filed a rejoinder and served a copy, ma. Now I may be permitted to have some.
Learned counsel for the which respondent?
Respondent 1 and 2.
1 and 2 submits that a copy of the rejoinder filed on behalf of petitioner has been served on him only yesterday. He therefore
One more submission, the respond number 3, GP for whom has to represent, my lord, the police.
notwithstanding they are not bothered, right?
No, not the Human Rights Commission. Respond number 3 is the.
No, what can we do if they are not appearing?
They are.
Notice has not been issued to them. Respond number 3 notice. Why should you bother for respondent which doesn't appear?
Their interim order has been taken as against them. The FIR was issued against some forest personnel.
No. So you are praying for time to file additional counter. We have granted.
Yes.
But we are asking how are you bothered about the person who is not appearing?
There is an interim order against the R3. That's how I am bringing to the notice of them.
They are not aggrieved. What is the inference? We cannot force them to appear and we cannot force them to issue a writ of mandamus to file vacate petition. Right? It's not aggrieved. Be happy. You fight your own battle. Don't depend on them. See. Next. We don't know. Don't know order has been passed. You didn't say anything. If you don't say any submission you make, then gone. It's no. This is only to emphasize that you should timely respond. You should have said that I appear for R3. Do I want time? In any case, it has been adjourned. Do whatever you want. Otherwise, don't do. We are not concerned. There's no. We are not interested. We are not interested in apology. We want unproductive matters to be finished in 30 seconds. We don't want to waste time. The very purpose of sitting beyond 1:30 is wasted on unproductive things. We are not interested. We don't know you. Why would we seek your apology? No question. Next. For you to decide. Yes. 25.
My lords, for the R6, my lords, need this time for filing counter, my lords.
25. This is under which act, madam, this 28/1/2020 order was passed? Yes, madam. In this, the debts recovery tribunal had decreed It's 2 weeks, good enough. Learned counsel for respond number 6, praise for and is granted 2 weeks time to enable her to file counter list thereafter. Next.
My lords, in these matters, my lord, these matters are covered by your lordship's judgment. These are with regard to spousal transfers, my lords, interstate transfer of spouses, my lords.
Yes, covered.
Yes, my lords. His lordship's,
No, not Thursday, 2:30. 2:30.
No, you should not be saying that. You know what is from 2017, we have been passing the same order.
Let the writ petition be listed for orders on day after is what, madam? 10th August. We will not wait on that day for you. Madam, if it's covered, you should be fair enough to say covered. If not covered, then argue. No, if it's covered, it is your duty to save time of the court being an officer of the court and assail the order. We will not record your concession, but you should save time. What brother is saying that since 2017 you are aware about the orders still and being
Not the party. What this court has been doing in interstate transfers vis-a-vis between AP and Telangana.
And you are a lady lawyer, madam. Should you oppose the cause of husband and wife being together? Not expected from you. 10th August. God bless you.
Sir, it's a similar matter of 7th matter, Miller. Similar matter of 7th matter, Miller.
2:30.
Notice.
2:30.
Notice, Miller. Similar matter of 7th
notice.
matter. Yes, Miller.
We said
in the similar matter, lordships issued notice on.
Yesterday, probably we told you whether it asked the tentative.
Yes, similar
Only
matter of
tentative list. Mr. Prabhakar, you remember yesterday,
yes,
similar matter you filed, saying I said it is only objection, calling for objections, though you said my seniority was decided long back, it cannot be re-looked into. We said all this can be said before the authority.
Yes, I have already made it, Miller.
So then what?
But they have not been considered so far.
They will consider that.
We'll direct them to consider for that.
Your lordship.
Whatever falls then with
Fine. In this writ petition, petitioner has prayed for a following relief. Learned counsel for the petitioner fairly submits that in pursuance of a tentative seniority list.
Yeah, final seniority already over, Miller, and again they are coming back.
That was previously. Now today, what is issued, what is under challenge is again a notice asking for objections from you.
The petitioner has prayed for following relief. Paragraph in this writ petition, the petition.
Time may be fixed. 4 weeks or 2 weeks.
8 weeks.
Oh, bless you. Deeply bless you.
34.
But I wanted to invite one provision. But I will submit locally.
I request.
No, we have all this thing recorded. What government says? Or at 2:30 then? 2:30. 2:30. 2:30. You call this number, right? 2:30. We'll take it at the end of motion.
This is at the end of the admission.
End of the admission. Please wait. End of the admission we will take up. Please wait. Yes. Yes. Hello. What happened, Mr.?
Didn't you lodge permits me?
No, we have recorded. You have understood your case yesterday only.
One provision I did not cite by both sides. I did, by oversight, I did not cite provision in my paper book, just I. If your lordship permits me, I will cite that book. But page 21, page, rules begins. GO begins. Page 18. The relevant provision is page 21. Page 21. But I will read two.
C2. C2.
3-2. If during the oath or made part of 7 constitutional certificate, your lordship linked to the academic year in which she appeared or as the case may be, first appeared for the relevant qualifying exam. She had not studied the local exam, but I resided in the state during the whole of the period 7 years, we regard the local career in relation to A, such a local area where she has resided the maximum period out of the said period of 7 years. Well, undisputedly, for 10 years I studied here. If qualifying examination is taken into consideration from that too, the major years are 7 years.
So you need not challenge the GO or whatever.
I did not challenge, I will withdraw first.
What do you say?
Say petitioner does not fall within the definition of a local candidate.
That is.
Lords may kindly may I just pass on the presidential order, my lord.
No, Mr. There is an interim order passed by division bench of this court.
Lord, that is, Lords may kindly see doesn't have a president value for the reason.
Admission to which course? MBBS? MBBS, no. What is the stage?
The MBBS.
And no, what is the stage of this?
First phase of counseling is over.
So she can now, if we grant her relief, she can participate in the second round of counseling.
My submission, Lordship.
No, we are asking.
Yes.
It doesn't mean that we won't hear you.
Yes, Lord.
We said, if we
Yes, Lord.
grant her relief, then she can be allowed to appear in second round of counseling. Your submission obviously is that petition should be dismissed with cost of 25,000 rupees.
That's right.
We understand.
I'm not,
Yes,
Lord, the
please.
dismissal for 25,000, please.
No. I mean saying that it's frivolous, right?
Lords may kindly see, my lord. The erstwhile state of Andhra Pradesh was divided in presidential order.
Yes.
Presidential order. The GO was issued in conformity with the presidential order.
But the same thing was there with that when interim order was passed by this court.
Lords may kindly see 4 to 1A to fall within 4 to 1A. Lords may kindly see the 4 to 1A. Then 4
second. Mr. Pravakar Rao, this order was passed in the way back in the year 2018.
That is, Lords may kindly.
You have you taken any steps to question this order or for any further action on this?
But that order is in contrary to the.
Same IPS officer there also, to the best of my memory.
Yes. My submission, Lordship. Yes, I will take your Lordship to 4-1 and 4-2. And I will take only 5 minutes. I just read 4-1 and 4.
We are not deciding this. We are only considering the prayer for grant of interim relief because you have to file counter and all that.
Order also, my lord, is not entitled for the simple reason it doesn't fall within the definition of 4 to A also.
No, what do you say for C2? C2. Please read your GO C2. That is what was considered by the division bench then. Please read 4C. That's C2, Roman 2. At page 21, C2.
For children of parents, let's say he falls below the 15% category, not the local candidate. He falls under 15%.
No, it's during the whole or may part of 7 consecutive academic years, ending with the academic year in which she appeared, or as the case may be, first appeared for the relevant qualifying exam. He or she has not studied in the education in any local area, but has resided in the state during the whole of the said period of service, be regarded as a local candidate.
My submission lordship says, my lord, study also, that the candidates who are resided here and studied, my lord, in private institutions, also, my lord, falls under local candidate. My lord, my submission lordship, may kindly see, my lord. DC lordship, referring to DC lordship. He falls DC lordships. The following candidate remaining 50% unreserved seats.
That is non-local.
C, not local.
That is non-local.
Non-local. C
But for C, how do you say that they are not up, they are not covered by C2?
But if we studied, we learn in any three regions.
No, even residing is permitted. Please read. Such local area has resided, maximum period. Residence is also fine, even if not studied. That is what the purport of C2. Yes.
Kindly see, my lord, Lord's kindly see, my lord, GO 646, I take yours. 646, page 81 of the papers.
Challenge the order.
Did you challenge this interim order of His Lordship Justice Ramsubramanian?
It's a debatable issue, Mr. You will appreciate. We are dealing with the life of a student. Debatable issue. By interpretative process of hearing you for half an hour, we cannot dismiss the petition today in the absence of counter.
Meritorious candidate of local candidate, blood is deprived of admission into.
No, Mr. Pravakara. As I understand C2A, education in Telangana is not a criteria. Residence is the criteria.
If a resident, yes, sir.
So today if I am residing here, but pursuing my education somewhere also, I am considered as a local.
Local, I just, blood if he studied beyond any of the institutions, not government institutions.
No, but it doesn't say so. Your
Yes,
GO does not say so.
President shall have to say so, Lord.
No, your GO doesn't say so.
Lord, may kindly see. Presidential order, Lord, yes, I passed on presidential order, Lord, may kindly have a look at it.
What prevails?
Not may kindly see.
Rules are only the person for the presidential. Presidential order only speaks of local, non-local, how to become. They don't look their friend their GO.
Yes.
So what is your submission? Like there is a conflict between presidential order 74 and your rules. So therefore presidential order will prevail.
Presidential order, Lord, may kindly have a look at presidential order.
Yes. So what happens when you preface your submission with this sort of an argument? We are able to appreciate better. Now we have understood, like your submission is, so now we will see, please point out which order.
4-1.
4-1. Okay.
Qualifying examination. Relevant qualifying examination, the interpreter.
Please read B second part.
That's all.
Come to next page. B1, B1. B1 also.
B1.
Such local area where he has resided
For a maximum period out of the said period of
7 years.
My submitted lordships in the 7 years.
So tell us how is it,
7 years to be counted from the preceding to qualifying examination. 7 years. Correct. But 7 years he has not studied. No, not studied, resided. The question here, there are two things. One is educational qualification study. Second is residence. Now here residence, they said out of 7 years maximum. It's also will have defined it. They never said resided and studied. They segregated both separately. One as a studied. And there of the concept.
Yes.
B versus B. Four consecutive years. 4 consecutive years, blood is not studied. Not studied, there is. Not decided. 4 consecutive years. 10th, up to 10th, she studied here. Yes. Correct? Yes. So studied here means she resided here and studied. Yes. 2 years she did not study. Yes. Now take 7 years. Out of which 2 years you exclude, whatever, what remains, balance maximum is here only. B doesn't fall blood.
All right.
That is 421, 421. That's my kind is 421. That
Of this order or rule?
presence order 4. 428. 4 because the candidate for administrative course of study because the local candidate and the person in relation to local area shall he has studied the research for a period of not less than 7 consecutive years. That's what it is. In the second stage, needs to be appeared as but relevant qualifying examination is the relevant lot from preceding to 7 years. Then 1 will not be. Such local area various study from maximum period of which is period 7 years. R. Please read. Period of study 2 or more local area. Such local area various study in such period. Everywhere it is R. That's my kind. Read B now. Read B. That's my kind is C. Geometry number 646 is that is clarified. 646 is clarified. And your lordships are finding. No, Mr. Prabhakar, please read B. B will give clarity. After that, R, B. If part of 7 consecutive years, we are giving it academic means here. He has not studied in medical school. But he has decided to residence can be considered into only in the cases where he has not studied recognized schools. Where are we? We have to assume so many things, Mr. Prabhakar, that is not permitted. Explanation is there. The question, Lakshmi, can you see? 4, explanation 4. Also, not with the parents or other guardian.
Immediately, for immediately proceed the test of conversion to filling from chemical. Yes, submission should be. There's not 15 people there will be that. Immediately, should want that is.
Particularly that 7-year class comes into force. 4 consecutive, that is why the difference, the distinction is one difference from 12 plus backward 8th class. So 7th plus onwards, if you have studied here, you qualify. That is 4 years.
Four in this.
Yes. Otherwise, it goes to 7 years. That means from 7th, 5th class onwards. If you have studied maximum here, then also you can be considered as low. Earlier, all this 2 years, people used to go outside state and read inter, like AP in Narayan, if they study, they don't become non-local here because even though they are studied from first to 10th year.
AG 86 of presidential blood, Geo 6.
No, only tell us one thing. Supposing we don't grant her the interim relief and she succeeds after you file counter, what will be done? What can be done? What relief? You will say all admissions over everything, over new seats.
I will not say, Lord. She will be accommodated as per their merit pursuant to the orders passed.
But you have the power to create a seat. You will keep a seat vacant. Which discipline?
I have already given an option, madam.
Which discipline? Which discipline you want? Like MBBS course where? Which course? Where? Which college you want admission?
No, college.
College.
As per your ranking.
103. Paper of 10.
Hey, tell us the name.
First part, Gandhi Medical College. Second after the Vishwania Medical College. Third, fourth, ESI, Medical College.
We don't know, Mr. You are undertaking how you are giving. We don't know which of the medical colleges she will be securing admission as per merit. So will you? So supposing if you keep one seat vacant in Gandhi Medical and she is found later not eligible for Gandhi some other college, what will happen? Or you keep one seat vacant in all the colleges indicated by the petitioner. Correct, right? Now we are directing.
No. See, this maybe she thought she will get in Gandhi Medical College.
And she doesn't get-
Or if my rank, if I am not within 90, assuming if I am not within 90, I will not get Gandhi. I may go to Usmania. Let's say even Usmania I don't get. My third option is ESI or fourth option is a private medical college.
So we will record your submission that she will get preference and you will keep 1 second. Huh? Correct.
No, they are keeping one seat vacant for you without filling it up.
Gandhi Medical College, which place?
Have not started with.
Hyderabad.
It's a Hyderabad.
All right.
No, classes have not started. It's still there in the processing of counseling only.
Mr. Ramakrishna, how much time will you file counter? Learned Counsel for Respondent. to undertaking business, inviting serious trouble.
My submission, first phase of counseling is completed. First phase of counseling is completed.
No, mister, you cannot have the cake and eat it too, right? Either you give an undertaking or we will permit her to participate in second round. That's according to us a better thing. Don't get into undertaking business. Why your clients will question who asked you to give an undertaking. Don't.
I got confidence, but that's why, because first phase is over, second phase will not be.
We'll allow them to participate in counseling subject to some of the.
Not give a date for it.
Yes, of course. Yes, heard on the question of interim relief. No, so, 1 minute. Mr. Senior Counsel, he is correct. The result will be announced only in respect of candidates who have participated in the first round of counseling. Did you participate? You did not.
That just showed as ineligible in the local candidate.
We are asking in your presence only. We have got your point. Correct. That yes, no, correct. You are correct. That if she has participated.
15%.
It is what then read the Madam Interim Order. Not in this, before it is directed. Today. Please communicate the order. Will certified copy today. We don't know. We don't
If
know.
she gets in 15%, she will not have any claim at all.
Because 102 is the rank.
No, that's what Mr. Prabhakar, if she gets in 15%,
You
she will
should-
not have any grievance, he will withdraw the.
You should
petition.
encourage meritorious candidates like her. Yes. Yes. Ah,
What is placed before my lord, sir?
yes.
Support by the, if the respondent is placed before my lord.
Yeah.
Steps which are taken subsequent to my lord's order. I just.
Which report, Mr. Where is it?
That's affidavit form it is.
Yes.
This one?
Put a flag, right? Yes.
The affidavit form, that's for affidavit filed by the sixth respondent.
Where? Memo? He's saying in the affidavit form.
On 7th of August, we filed.
It begins like event, forecast.
It is the affidavit of the respondent number 5.
Affidavit, madam. It
Bringing-
is like this.
This is the affidavit, right? I'll give the USR number to the officer.
These people have not put a flag on that, so we are struggling to find it out.
But may I pass on a copy?
Additional affidavit and petition.
No, ma'am. It's a plainly an affidavit by the respondent number 5, filed on the 7th of August, right, subsequent to my lord's order.
It's not on record, it appears.
May I just pass on a copy for my lord's perusal, ma'am?
You have Mr. Prabhakar.
Yes, Lord. I have served it on my feet.
Huh?
I have served
No,
this
no,
copy.
but see, we don't have it. That's the problem. When did you file, Mr.?
On the 7th of August, 7th.
Learned Council submits special counsel tomorrow. Learned special counsel submits that in compliance of the order passed on.
The fourth one, 1/8,
Huh?
1/8/2023, 2 days.
1/8/2023.
And
The
28/7/2023.
28/7/23 and 1/8/2023. The respondent number, who is?
Respondent number 5 months.
5. Who is he?
That is the secretary for disaster, secretary of revenue to government revenue disaster management.
Has filed an affidavit on 7/8/2023. However, same is not on record. Let the writ petition be. Let you get, madam, that
My
affidavit.
USR number, take USR number and.
USR
I'll furnish the number right now.
tomorrow. Learned counsel for R5 praise for India's granted. 3 weeks time to enable him to file counter list thereafter.
Item 27, pay evidence. Issue.
My lords, I have filed an implead petition. I was not added as a party, my lords. My lords, in fact, there's no public interest in it. It's just it's an exercise of extortion against the unofficial.
Extortion?
Yes. I have
Where is
stated.
the petitioner? Not there. Ledger? There's no interim order, right?
Yes.
None for the petitioner. So and so for respondents awaiting appearance. Hearing is deferred. List after 2 weeks.
My lord, it's for the petition.
He's in the better company of GP for revenue. Huh?
Yes.
Yes. Yes.
My lord, in item 38, I appear for the respondent writ petitioner. It's an appeal, intra-court appeal filed by the state.
Your Lordship, I beg to represent for Dr.
Implead petition, Mr.
My lord, these are persons who are coming for impleadment in the appellate stage. They were nowhere in the before the learned single judge.
What is
They are.
what is-
Matter is like this.
What has learned single judge done in substance?
Petitioner, my lord, has purchased a parcel of land and applied for mutation under the Revenue Records Act. Mutation was granted.
Have you filed objections to this IA 1 of 21? Implead
Yes, I have filed objection.
objections to IA.
Yes. I'm opposed. My lord,
Oh, CS 14. It has to go before appropriate bench then. Let this writ appeal be listed before the appropriate bench. You understand? Friday it will come up. Appropriate bench as the subject matter of this petition pertains to CS number 14.
It is
14 of 1958.
Friday, your lordship may say.
It will come up, obviously.
Only Friday.
Only Friday.
2016 matter, my lord, on the ground that this is connected. Actually, it is not connected to CS 14 at all.
Your Lordship, it's a connected matter.
My vendors have purchased, my lord, from the
Then
persons
you
who are
file an
degree holders.
application. File an application so that he has the right to oppose, not like oral submissions. No, then senior counsel should have a prior time to respond, right? Orally, you are saying that he doesn't even have the time to react. Delete, Madam Learned Additional Advocate General, whosoever. What you are GP, government pleader, prays for adjournment in order to enable him to move an appropriate application seeking hearing of this writ petition before the appropriate bench. Needless to state that respondent shall be at liberty to file objections if so advised.
May kindly post it to Friday, my lord. I don't want this application, and this application process will
Delete.
Procedure delayed.
That's why the same order, appropriate bench on Friday. What Friday? 11th August.
Right.
This matter is next connected matter.
39, madam. You have.
40 go to.
39 is an implead party petition in 38. 39, item 39 is a petition.
Same order, right?
38,
Same order.
Both go together.
All right, 38, 39, same order, but 40.
Item 40, they say GP for labor. So,
Please see what is, I haven't seen. Condone delay.
My lords, I'm appearing for respondent number 2, your lordships.
Yeah.
My lords, the council is out of town, your lordships may have it other day. I have a stay in my favor.
Learned senior, learned so and so learned counsel for respondent number 2 prays for adjournment on the ground that arguing counsel Mr. So and so it out of station. Interim order granted on earlier occasion shall continue. List after 3 weeks.
Great.
May it please your lordship.
This is W.
My lord,
Yes.
I may be permitted to appear on behalf of the
Yes,
writ
of course. Yes.
But IA number 2, 3 and 4 are filed by proposed respondents, my lordship. IA 2 and 4 are implete petitions.
You are for the appellant.
I'm appearing.
So are you opposing these prayers?
Yes, my lord, I'm opposing.
Do you want to file objection?
Yes, my lordship.
Learned counsel for the appellant praise for is granted.
How much time?
2 weeks, my lord.
2 weeks time to enable her to file objections to IA 2 of 23, 3 of 23 and 4 of 23.
Obliged, my lordship.
List thereafter.
That my, changed to IA number 2 by 23. File that,
She wants to file objections, right? Next, 42. So they have not filed counter, right?
Counter is already filed.
When?
Long back it is there in.
31st July, we were told that not filed.
There was some
Second respondent to issue the GO, my lord. They are not filed counter till now.
Also, we have said that if in case it is not filed, this thing, who is this Anagala Dipti? Who is?
Yes, myself, my lord.
Then
My lord,
you, madam,
second respondent and third respondent are in the same department, my lord. Women and child welfare.
we don't know. You had sought an adjournment on the last date of hearing. We said,
Yes. Yes.
We said that week's time is granted, failing which appropriate orders. Now you decide for whom you are appearing.
Actually, my lord, I'm representing women and child welfare department, my lord.
We don't know which respondent.
Respondent number 3 has filed counter.
3 and 5.
That would suffice in the manner.
3 and 5. There is no 5.
3, my lord, 3.
3. You have filed.
Yes.
Learned so and so, write her name. Today submits that she appears for respondent number 3 and has already filed a counter. No counter has been filed on behalf of remaining respondents. Petition is admitted for hearing.
Respondent number 3 representing respondent number
Otherwise, it may not be come in the
The
list.
counter deposed by respondent number 3 also represents respondent number 2 and 4. Lord, I'm very sorry.
You should, what should you do if you want to adopt the counter memo? At least you should file adopted counter or make oral submissions.
They are in the same
Don't
department.
file.
That is stated in the counter affidavit itself, that they are deposing on the behalf of second and fourth respondents.
You have not said so in your counter saying this.
I've said
Please read, where have you said it is being filed on behalf of other respondents?
Paragraph 1 below, counter affidavit by the respondent number 3 and the third respondent herein, as such well acquainted with the facts of the case, I am authorized to depose on behalf of the other respondents as well.
So it is the counter on behalf of all the respondents, including the state.
Learned counsel for respondent number 3 today submits that she has filed counter on behalf of all respondents. Petition is admitted for hearing. You want to file any rejoinder, madam, to this?
Already filed, my lord. I filed additional material paper for that, my lord.
No, rejoinder you have filed. If you want to file or don't want to file.
I will file, my lord. I will file.
Learned counsel for the petitioner praise for is granted. How much
Submission in
time?
this regard, my lord.
How much time, madam?
Next week, my lord. Only one submission in this regard, my lord. Who issued GO, the second respondent herein is not filed any counter. The third respondent have no right to file the
that
counter. Yes.
You should feel happy about it. You can still argue.
They are making a mistake, allow them to make a mistake.
Allow them to make a mistake. We have only said, we have not said that the order, this no court order, per submission. What is the effect? You can counter, be happy. She will get alert, and supposing she files an application meeting, why should you give away your peace of mind? Whatever you want to argue to her notice, don't say. You want to file rejoinder? Don't want. Rejoinder within 1 week is thereafter.
I will file, my lord, next week.
Not next week. It will come up after you file rejoinder. Yes.
Obliged.
Ah.
This matter, the learned senior counsel, Mr. C.S. Vaidyanathan is leading us.
Yes,
He has joined virtually.
Yes.
Make this lordship.
I'm appealing for respondents in this matter. Respondents, Transmission Corporation of Andhra Pradesh. They filed an IAM served on Friday.
What was served on Friday?
Granting 10 days.
The matter has been heard on several days. In fact, finally, the final hearing also took place. It was only to submit the rejoinder, but meantime.
No, Mr. Vaidyanathan, you know that if you argue before this bench, the judgment would follow.
Yes,
No, you can share from your Karnataka experience, you can share with your learned counsel. So, but counsel, some senior counsel, for which respondent you are appearing, Mr.?
Melida, I'm appealing for respondent number 4.
He wants 10 days time, Mr. Vaidyanathan.
Meantime, I don't want to precipitate action. We had an order which continued till January. Let the matter not be taken up on 5th January, and therefore the interim order expired. When the matter came up on 20th February, my lords observed after hearing me partly. Then in case there is any precipitation action, we have to make a mention. Let the matter heard.
Respond number. Yes, Mr. Who is taking action against you, Mr. Vaidyanathan?
The central government has made a statement in the parliament day before saying that.
Also, there is already an interim order since 28th of September 2022.
That's
So,
subsequently, that was there. Subsequently, that order got expired.
And it's being adjourned at the instance of respond number 4. So don't.
No. That's absolutely incorrect. The stay was granted. It was an ex parte murder. It was granted on
28/9.
That's right.
Yes, 28 September 2020.
Yes. And there was, meanwhile, Mr. As both of you are and everybody is appearing, what happened? There was a suggestion made by this court to negotiate the dispute and to settle it, right?
But they never wanted to negotiate. It's clear from the various documents I have filed. They have made a submission before the government of India that they don't want to negotiate. Government of India appointed a subcommittee. It's recorded in the minutes. It's recorded in the minutes.
But we as senior counsel, we just wanted to know, 1 minute, Mr. Vaidyanathan, for what purpose you are seeking adjournment 10 days time?
I need to file a counter affidavit. They have filed a fresh IA. I need to file a counter affidavit. They are relying on some
IA which has been filed.
Yes, man.
Okay.
In the main read, the pleadings are complete. I am ready to go on with the matter. If the court takes up tomorrow or on Monday, whichever date that's convenient to your lordship. An amount of 6,000 and not.
Yes.
Due to
70,000 crores is due from
whatever that will. That's on merit.
They can't go on bringing this. This is the amount that Transco spent on generating power post bifurcation.
All right.
After the bifurcation, by virtue of a direction given by the Union of India under the Electricity Supply Act, we had to generate the power and supply. We purchased both.
Yes, correct. So this is the order impugned in this petition is an order under section 92 of the AP Reorganization Act.
That's 2 minutes.
So just this thing query, since it's being adjourned, but we want to know whether the petitioners have been heard before determination of their liability.
No.
Yes.
Just
They have never. My submission is yes, and second submission is going to be that they have never disputed them. On the other hand, they have accepted them.
All right. So, but you want to file counter to which IA?
The latest IA 1 of 23.
1 of 23. What is, what is the prayer, Mr. Vaidyanathan, in IA 1 of 23?
Yes, the IA is to continue the order which has been passed, extend the interim order passed on 28th September. And so that no precipitate action is taken.
Yes, all right. So, Mr. You are going to take action against that?
That is the apprehension.
Apprehension. What are your instructions?
My lord, I did not receive an instruction because only Saturday I received the papers, my lord. I need to get instructions. And by the next day of hearing, my lord.
We will grant a date. Till then, don't take an action. Let our respondent number 4 file a counter. We will hear it on this IA.
Yes, yes.
May I make a submission?
Which date suits you? Both of you, please tell.
May I make a submission?
Yes, please.
Instead of taking up the IA, heard finally and almost at the stage of reserving for judgment. At that time.
But you will appreciate it was not heard before this bench.
I understand.
We assure you, but if you argue, the only judgment will follow.
I am not asking you lordships to take forward from where the earlier bench has left.
Yeah, of course. So which date suits?
If it is for final hearing, my lord, 5th September. If it is a IA, my lord, it can be even next week, my lord, whatever.
Yes, Mr. What do you say?
My lord, I am ready to go on, my lord, for final hearing, my lord, sometime next week itself.
Next week, my lord, some matters have been.
My lord, this has been happening, my lord, for the last almost 1 year.
I have no problem, my lord,
for the last 1 year.
Mr. Yes. Please appreciate this court would not like to this thing get into that dispute of a dates between senior counsel. You both of you should come up with an agreed date. Please tell whatever I am.
From 5th September on a day-to-day basis, my lord, it's only three weeks away. 5th September.
My lord, almost a month, my lord. My lord, you lordship, I have looked at the dates that the matter had come up on most of the occasions, on every occasion.
Mr. Any other date, earlier date?
No, 24th, my lord, 24th of this month, my lord, subject to my lord. 24th.
24th August.
Very well. 24th.
Yes. Yes, my lord.
Yes.
So, we fixed the petition for hearing itself.
Very well.
Yes.
Mark everybody's presence, taking into account the nature of controversy. Learned senior counsel for the party.
from January 2023
Ah.
till now, my lord, there has been no, my lord, interim order.
Hmm.
And my lord, what have they filed along with the IA? They have filed, my lord, some newspaper report saying that there is likelihood of precipitate action. They have not filed any other document.
What
And
is
we
the
will-
In the parliament.
My lord, you better say that we will not do it. Yes, my lord. There will be no element of adjudication. Otherwise, senior counsel for respond number 4 is praying for time.
So, my lord,
We will have to grant time. Then
One submission,
instead of
my lord.
hearing,
the papers were served me on Saturday, my lord.
you don't take action.
What is the exact stage, my lord? Exact status, I do not know right now, my
Then
lord.
tomorrow, no.
Tomorrow I'll get instructions, my lord. Lakshmi direct me, I get instructions, oral instructions.
Mr. Vaidyanathan, tomorrow, this central government standing council is praying for time to seek instructions.
Because I need to get
Tomorrow on
instructions.
interim relief,
Very good, very good.
delete everything.
Tomorrow for instruction, written instructions, lordship, I'll get it.
Already, your
From the
lordship,
department, my
know
lord.
the date.
Only, my lord, if I say something.
No, I mean, ideally speaking, Mr. It has been entertained 20th September 2022 interim order has been operated. They can't disappear, no flight risk, right? Petitioner is not at flight risk. So what would have, we had fixed the date. What would
Lordship
have
has
happened?
24.
But we thought that probably you will take the matter to Supreme Court. So therefore we have to, this thing, then pass a
No,
detailed order.
your lordship
We have
has-
already fixed a date for hearing on 25th. We said first case in the hearing list.
Your lordship may continue with that. Your lordship may continue.
So then interim order, right?
Yes, that's very good.
Careful.
24th August as earlier order, then which you have heard.
Grateful.
We have fixed the case for final hearing on 24th August 23. It will come as item number 1
Grateful, grateful.
in the final hearing list. Item number 1, tentatively later half of the day. You can expect around 3 o'clock we should be able to take up.
Grateful.
Yes, senior counsel, respond number 4.
Yes, my lord says.
Okay.
Blessed.
We may have the copy of the order today.
Yeah, what copy? You have been sleeping since 28/9. What copy? He pointed out, no? We have said no coercive action.
This matter actually for the petitioners, senior counsel, Mr. C. Damodar is appearing, but he couldn't attend launch.
What meeting?
But senior counsel C. Damodar is appearing in this matter.
You want adjournment?
Yes, Lord, Lordship may grant some time.
Land of the bar is disputed and the bar is not the petitioner.
But it is saying for adjournment.
We only need to file. There is no.
President.
But he is not the president.
Are you president of this association?
Yes, my lord, he was the president.
Was.
Yes, presently, after the election, my lord, he is no more the president of the bar.
Think about it.
We have to file an application also, which I'll do.
On the last occasion.
Yesterday there was a meeting.
Yes.
Yes.
Are you aware of it or not?
No, yesterday, I am not aware.
Sunday.
No, yesterday.
Yesterday.
I'm not aware.
Yesterday meeting.
Yes.
Everybody has agreed.
Mr. What happens that this thing create all sorts of obstacles. This land, you are saying that we don't want. It will be allotted to somebody else and another 10 years. What for it coming from one advocate? How do you, on what basis you say that this thing represent the will of the bar association? Individual can have any grievance.
Not individual, Lord. There was a resolution from the bar.
Now the bar.
In fact, my lord,
president was
Yesterday.
there yesterday.
Yesterday's meeting, I'm not aware. I'll also
Then
get
that's
instruction.
what
I'll also
brother
get.
is telling you.
in fact, my lord, there was an
What
observation.
happened in yesterday's meeting?
Observation was held on the last occasion, my lord, for the administrative judge and all of them to meet up and finalize. The
We
report
are
has already,
step further. What happened?
my lord, the report has come to the court.
You are there in the meeting, not there. You don't know. So say I
In
didn't.
the meeting.
I don't know.
I don't
because
know.
I did not attend the meeting. This.
Yes, my lord, I'm not in the meeting.
is the report. Submissions, everything.
There was a direction, my lord, from the last.
No, so there was a direction, there is a report.
Report
which has been attended by honorable judge, which every one of you, each one of you has attended under the chairmanship of honorable judge. The report has been submitted. We don't see any reason to this thing. Take a different view. Every stakeholder has agreed that the construction of the
proposed site is suitable for
table and district court complex it should be. Individual view will not prevail.
Lordship, yesterday there was a meeting. It seems Millers are not.
The next is SLP.
No, Millers, Lordship may take it up in some time so that
No, pendency of this matter will this thing government will say matter pending before High Court.
Day after tomorrow, Millers. No. Only one day or a day. The senior
We told you. We told you the report. No.
Senior counsel is appearing.
Report. Senior counsel cannot alter the report which has been submitted to us in sealed cover.
I'm not on that.
We are not interfering. This court under Article 226 cannot decide where the location of this thing has to be decided. In exercise of powers of judicial review, we cannot decide where which place headquarter of a panchayat should be, how many places should be included in a district, where district court building should be. Your grievance was like that. All stakeholders have been consulted, and by a process it has been recorded in the report that everybody has agreed.
Lordship may do it in
Please cooperate.
The presence of the senior counsel may request.
No. Sorry. Each day's pendency of the matter will deter the government from not. They will say matter is pending before state government, the court. We will not pass an order.
It's tomorrow or day after tomorrow. May I request, Millers?
We can close it. It is our meeting.
Fine. We will record your submission that you want adjournment, right? Where is this thing order saying that there should be a meeting? In this writ petition, petitioner
Taking direction from the Honorable Court not to construct a rice mill in the
Huh?
Khanapur village in
To
Medicine.
construct what? What to construct what, madam?
Rice mill, Miller.
Rice mill. Rice mill.
Yes, Miller.
Who appears?
I am for the respondent number 5, my lord. I am for the respondent number 3, my lord.
No, this 3, 5, what, who are state pollution control board?
My lord, page number 21, my lord, for a moment.
Municipal corporation, what do you say?
Yes, my lord.
Construction of a rice mill in accordance with law?
Last occasion, this honorable board pointed out, my lord. Last occasion, this honorable board directed, my lord, the petitioner council, my lord, to amend the prayer, my lord. There is direction to stop the construction, my lord. Already construction is over, my lord. That's why, my lord, the writ petition became instructed. Last time, they also submitted before this court, my lord.
Construction is complete.
My lord, page number
You
21,
can
my
take
lord.
recourse to the remedy.
My lord, the grievances of the petitioner are already informed, my lord, by page
We
number
don't
21.
know. If the grievance survives, she can file a petition. In this petition, the petitioner inter alia seeks a direction to respondents 2 to 4 and 6 to 7 to stop the construction.
May I please? I am challenging you 430 GO dated.
Rejoinder.
6/3/2008, my lord.
My lord, I am
Rejoinder.
respond number 5.
Counter affidavit.
R6 I filed, my lord.
I request
lord,
also
filed
file
reply
not
also.
by lord.
Rejoinder file. Pleadings
Is
are
it not
complete.
yet filed, my lord? R5 is not yet filed.
Not, who has to file counter? Who? Learned counsel for respondent 1, 3 and 4. And counsel for R2. Pray
My lord,
for
I
and
am
granted
appearing for R5 also need to file counter, my lord, each time.
5.
R6 I
As
filed
well.
counter, my lord.
R1 to R5. Pray for and are granted 4 weeks time to file counter. List thereafter.
I appear for the respondent number 8 in this matter.
Ah. Yes, what? You have filed counter, right?
For petitioner, my lord.
Appearing for R10 13.
They are not interfering with the lands reserved for graveyard.
Yes, yes, my lord.
So,
Lord,
you are saying yes. So means you agree.
respondent 5 and 8, I had to file counter, my lord.
5 and 8.
5 and 8. I wait left the respondent.
5 and 8 file.
Respondent number 5.
Let counter, if any, on behalf of respondent 5 and 8 be filed within a period of 4 weeks. List thereafter.
Hearings are completed.
No. 8 is home.
5 and
department.
8.
8 is home.
We have said if any, still, because he didn't say he wants to file counter, so we have given him option. If he wants to file, fine. Doesn't want to file, it's his choice.
Obligement. The only,
You should say respond number 8 want to file counter 4 weeks time.
and I'll make sure I say that.
Next, madam. 50.
50. And for petitioner, it's not. I may be permitted to withdraw the writ petition, my lord. We have advised our client to file a comprehensive declaration suit in representative capacity. He has filed before the Honorable Additional District Judge Maychal, my lord. By
In the light of observations contained by a division in the order dated 11/7/2020-23 passed by a division bench of this court, learned counsel for the petitioner seeks leave of this court to withdraw the petition. contained in the order.
My lord, my kindly
We are
refer
aware
SR number
that
also.
he had
SR
filed.
number also I am stating, my lord, we have already filed, my lord, SR number also there.
We don't know.
Much obliged.
TL enforcement.
May it please, my lord?
Counter fight.
Not filed. Counter has to be filed.
Say,
Yes.
learn it. So, respondent number
3489.
3489. Praise warrant is granted.
I filed complete petition.
Let counter, if any, on behalf of respondents be filed within a period of 4 weeks.
IA number 2.
List thereafter. We
IA number 2.
consider next date. This is PIL. If you have an individual cause of action, go and file.
I filed the implicit
You
petition.
are an encroacher. That's why you want to oppose PIL, right? Then
My lordship may hear me for a second.
we will hear next date of hearing.
Yeah.
No urgency. This is public interest litigation.
Yes, my lord. Yes, my lord. Public interest litigation would have been sought on a public land, but this is a private patta land which has been demarcated.
We will hear. We are not.
That they have to say, revenue department has to say.
We are not passing any orders on your IH pending list. You file response, Mr. Petitioner. You file.
Much of it.
Huh?
My lord, actually,
Petitioner, if so advised, may file counter to implead petition.
yes, like spring.
Before next date of hearing.
My lord, only one submission, my lord. Your
You
lord,
don't want to file counter.
yes, my lord, I will file the counter,
That's what we have done. Nothing is done.
but one submission, my lord. My lord, actually, they have filed a writ petition in the year 2022, my lord, last year. Seeking the relief that
No, you want the petition to be heard without counter, right? That's why you are arguing.
not
We can't decide it. It's a public interest litigation. The tank does not belong to you. Please remember.
much of,
Huh?
only one,
It belongs to you.
not with regard, my lord.
What? The tank belongs to you.
No, my,
Yeah. Public interest litigation, your role is over.
no, one fact,
Once we have taken cognizance, your role is over.
only one fact.
You are in the capacity only to assist the court.
Yes, my lord.
And we are giving them to file counter.
Only one fact.
After the time was granted to file counter, learned counsel for the petitioner submitted as follows.
One 2017 is also filed with regard to the same lake, my lord. With regard to the
150.
150 of 2017, my lord. That is also.
You want it to be heard?
Yes, my lord. That it is filed by the learned senior counsel KS Murthy, my lord. As he was.
No. So we will appoint an amicus in case you are diffident that you can't espouse the public cause.
No, my
You
lord.
want to rely on the senior counsel. So that means
No.
don't you are
No, my lord.
declaring that I am ineligible to assist this court. So please hear senior counsel. We will appoint an amicus.
My lord, that is not my submission is, my lord, that said PIL has been filed by the then counsel KS Murthy. He was the counsel. That is my submission, my lord. And it is filed by the petitioner is one Goody Karunakar, my lord.
So same petition, two petitions filed for same and your petitioner is common.
No, my lord. The petitioner in that PIL is, but the lake is the same, my lord.
You are correct that this is not in bona fide public interest because it is coming out of the back. You have remained.
Let me make PIL has filed with regard to the encroachment of the lake in the survey number 135 and 136, my lord. Whereas this is with regard to the survey number 205 and 205 by 1, my lord. Cause of action for filing this PIL has arose in the month of May, my lord.
Did we say that the cause of action arose in month of December? So you are saying that March. We didn't say anything. You did not hear the order. Why are you arguing? We didn't say anything.
My PIL is a bona fide PIL, my lord. It is not my, only I would.
We didn't say anything.
Say anything that is bona fide.
You are arguing, mister.
I think all the unnecessary issues.
We are granting them to file. We have granted them to file counter. No construction can be there in FTL level. You file objections to his impediment. Nothing. You are saying.
No, but my only submission.
Why?
PIL also.
Why? I mean, you are bent upon wasting the time of the court in unproductive things. So that who has said that PIL and this PIL? We don't know which PIL. You want it to be heard together, file an application.
And also.
No, not oral submission, because many a time we have people casually make statement. Today a party in person said in mention memo that my case is not listed despite fixed date being given, and his case was at item number 18. So don't make such statements. Nobody is saying, none of them has said that the same petitioner has filed same petition, another petition through another council. So why are you justifying that it is filed by a senior council? Senior council is never files a petition.
My lord.
Senior council, for your information, never files a. Shouldn't waste time, young man. We will replace you then
My lord.
by a senior council.
Only one submission.
No.
Mr. Council, we have
Enough.
enough, please.
He is not a senior counsel as when it is filed, my lord. Subsequently, he is
We
designated.
know not.
You said senior council. Is it relevant for the? No, we will replace you, mister. You don't have a right of audience. Don't think that you can talk nonsense in a public interest litigation.
No, my lord.
No, we want to. After the order was passed, Mr. So-and-so started making irrelevant submission. Therefore, we appoint learned senior counsel to assist as amicus. We will give the name to assist us in this public interest litigation. Over.
Apologies, my lord.
My lord, in this matter, I'm appearing for respondent.
This is not meant for this thing. Public interest litigation is a different ball game altogether. You don't realize. You are sitting here to oppose him. That's why.
No, my lord. My only submission is, my lord, petitioners are different, my lord. That is what I.
Who is saying petitioner is same? Did anyone say? No. Did we say? Whether they said? Some substance in what you say. Correct. Delete everything.
I only
You are youth and inexperience. We are giving you the benefit of doubt by deleting the later part. Don't do it again. Otherwise, we will, in a public interest litigation, we will ask you. Putting you to all these people notice, we have been there, mister. Much more experience than we have spent 20 years in that bar. We understand how public interest litigations are filed, who sponsors them, everything. And we are not asking anything to you. We are granting time, despite that you are bent upon wasting the time of the court for some unknown reason. Be careful in public interest litigation before this bench. Right. Correct. Yes.
But in this matter, I'm appearing for GHMC, my lord.
Status report.
What
is this, mister?
They have conducted inspection, my lord. The report is ready. Your lordship, I have it next week, my lord. I'll file it.
Learned counsel for GHMC undertakes to file the status report on or before next date of hearing. List on 18th August 23.
Published.
Yes. Mr. Senior Counsel, before hearing you,
I am appearing in item 54 minute.
Yes. So before we hear you, please see this order.
I had an application to go. I've gone through.
So this order you will appreciate that binds us unless you can see.
You'll actually take up my paper book minute. I will.
No, 53 number. We'll talk one by one. No, one by one. We'll take 53.
It may be different.
Wait. Right, same order, madam.
20623.
Order dated 23rd March 2023, passed by Telangana State Pollution Control Board in by which directions under section 33A of the Water within bracket Prevention and Control of Pollution within bracket Amendment Act 1988 and under section 31A of the Air Prevention and Control of Pollution, not Amendment Act.
But I am challenging a order dated 21/6/2023 at page 28, levying a environmental compensation under the Water Prevention and Control of Pollution Amendment Act 1988 and Air Prevention and Control Pollution Amendment Act 1987.
So this is an order under which provision?
Under the, one is under Air Pollution Act, another is under the Water.
Which section of the act?
Page.
See, you understand which context we are this thing.
Yes.
Directions under 33A and 31A.
Yes, 33A and 31. Yes, sorry.
Yes.
But this issue came up for consideration before the Supreme Court with regard to an order, comprehensive order passed under both the acts. That is at page 73. Paragraph 2. The argument of the learned counsel for the appellant is that a combined order was passed on the ground of violations under Water Prevention and Control of Pollution Act 1974 and Air Prevention and Control Pollution Act 1981. The order under Water Act alone is appealable before the NGT. Since the order impugned is the combined order under the Water and Air Act, therefore the remedy of the appellant is by way of writ petition in view of paragraph 36 and 46 of the judgment of this court in Tamil Nadu Pollution Control Board and Sterlite Industries Limited, reported in 2019.
Give Madam 2019 volume 19.
I have given the what up?
Give you give her this thing, no copy of the judgment or not here. Don't supply.
I gave the citation, requested the court officer to take out the.
Supply.
No. They slip to the court officer. They want the books ready.
You should keep the citation 2 copies ready so that we can save time.
Yeah. Sorry, Milad.
We will now, I think, search and then.
I have given the slip much earlier.
So do you mean to say that the orders we are asking, Mr. Senior Counsel, do you mean to say that the orders passed by us in batch of petitions and yesterday relegating them to alternative remedy
modified? Because
which we have passed just now.
Yes, sir.
Modified in the sense why?
Because under the Air Act, there is no straight appeal to the NGT. That is what the Supreme Court has said in paragraph 36 of the judgment.
Air Act.
In the Air Act.
See 31 capital B.
Yes, madam. 31 capital B.
Appeal to NGT.
Any person aggrieved by an order or a decision of the appellate authority. But after the appeal is over under the state procedure, then I can go to the NGT. 31B. You got me? See, appeal is under section 31.
31.
Any person aggrieved by an order made by the state board under this act may within 30 days from the date on which the order is communicated to him prefer an appeal to such authority as the state government may think fit to constitute. So I have to exhaust 2 remedies under the state act, then only I can go to the NGT. That is the judgment, paragraph 36. Para 36 at page 516. Orders passed under section 33A of the Water Act and section 33A of the Air Act. We have referred to the orders dated so and so passed by the TNPCB under section 33A and 31A of the Water Act and the Air Act respectively. At this juncture, it is important to state that section 33B of the Water Act and section 31 of the Air Act were both enacted on so and so, which is the very date on which the NGT Act came into force. What is important to note is that whereas the section 33BC of the Water Act read with section 16C of the NGT Act make it clear that directions issued under 33A of the Water Act are appealable to NGT. Directions issued under 31A of the Air Act are not appealable. In fact, the statutory scheme is that the directions given under 31A of the Air Act are not appealable. This being the case, all the aforesaid orders being composite orders issued under both the Water Act and the Air Act, it will not be possible to split the aforesaid orders and say that so far as they affect the water pollution, they are appealable to the NGT, but so far as they affect the air pollution, a suit or a writ petition would lie against such orders. Sri so-and-so argument that these orders being substantially relatable to the Water Act would therefore not hold as such orders are composite made under both the Water Act and the Air Act. Equally disingenuous to the reference to section 14 of the NGT Act, which only refers to the original jurisdiction of the NGT and not to its appellate jurisdiction. Also to state generally that subject matter of the environment lies with the NGT is an argument of despair that must be dismissed for the reason that, as held by us herein above, an appeal being a creature of a statute either confers a right of appeal or it does not. In the present case, we have seen that so far as the directions issued under 31A of the Air Act are concerned, there is no right of appeal conferred by the Air Act read with the NGT Act. The ingenious argument made by so-and-so that in any case a direction under 31A of the Air Act is nothing but an order and would therefore be appealable as such under section 31B of the Air Act read with section 16F of the NGT Act.
No, so Mr. The outcome is that if a composite order is passed, it can be challenged in a writ petition in exercise of judicial review, long and short of it.
Yes, sir. Yes.
And this court, I mean, you know,
Has got a jurisdiction.
no, jurisdiction, but parameters are defined, you know.
True. But here is also a case on merits of the
Where they have said, aside the order,
because they have
and
not
said that this thing.
para 45 and 46.
Correct. So what is challenge on merits?
On merits, Millard.
It's just short ground. We are not hearing finally.
Yes. In fact, there is a little order in my favor.
What is the challenge on?
Challenge is, Millard, they have levied a compensation, whereas on February 2023, they gave me a consent order that there is no violation of the provisions of the Air Act or the Water Act. 8/2/2023. Then this.
What? Just a minute. Wait. Who has taught you all this? Like intervening when senior counsel is speaking, and
I'm so sorry, madam.
you have drawn our attention that you are standing. We would have heard. We just trying to understand.
I'm so sorry.
No order will be passed without hearing you, right? We cannot pass. So Madam, 8 on 8th just February 8 to 2023, at page 39, they gave a consent order that my industry complies with the provisions of the Pollution Control Act and the
Water and Air Act.
Yes.
And then what
they issue a show cause notice on the basis of show cause notice on 22nd May 2023.
22nd May
2023. I submit an explanation on
just a minute. Show cause notice saying that you are violating Air and Water Act.
Yes, not yes. On the basis of a NGT order issued against other persons, where we are not parties. I submitted an explanation on 2nd June 2023.
2nd June
2023.
Explanation.
Yes, ma'am. They do not take that into consideration and pass the order on 21st June 2023.
So your submission is that your explanation has not been considered.
And my consent, which was given on February 2023, would show that I have not been violating any process.
This has not been considered. So we can are subject to hearing him, know what order.
Yes.
Also, eventually it has to be remitted to them.
Yes.
What do you say?
I will take a file report of the full sorry for intervening in my lord in this matter. Pollution Control Board was filed a report, my lord, because before notice was issued, hearing was conducted and.
No, did you hear what senior counsel said? On
8th February.
Tell us what he argued. What did he?
Yeah, the Senior Counsel in the beginning had argued on the maintainability aspect, my lord, that relied on Supreme Court judgment, my lord, of Sterlite Industries on the question of jurisdiction, my lord. Subsequently, my lord, the senior.
What is the first submission? What are the facts told by him?
Insofar as Supreme Court judgment is concerned, my lords, insofar as Supreme Court judgment is concerned, my lords, it involves the interpretation of Air Act and Water Act, whether appeal is available to NGT under the Water Act. Also,
No, we are not asking for your argument. What did he argue?
Submissions, my lords, was.
You can, if you understand, then only you can answer, right?
Yes, my lords.
The submission is that if a composite order is passed under the Air and Water Act, the Air Act being not directions under Air Act being not applicable, against a composite order, the writ petition would be is maintainable before the High Court. This is number one. Second is on 8th of February 23, you granted him consent saying that he is complying with Air and Water Act. Therefore, based on a end up explaining to you, right? So what I mean, so then it has to go back to you to decide after considering the fact that you had granted consent on 8th of February 23 and to consider his explanation and to pass a fresh order. By a speaking order. There no status report.
In this matter, my lord will permit me, my lord, I have only one submission to make insofar as the consideration is concerned, my lord.
You will recall the earlier.
My lord,
yesterday they signed review. That yesterday they have already signed that order saying about this judgment not considered. Only today we will each case.
As a show would be.
There is no point in keeping this petition pending. You don't understand, Mr. Counsel. There is already a stay operating. He will be very happy if we admit it and keep it for 20 years. By the time you are designated as senior counsel by the full court of this court, you will like to oppose him as a senior counsel.
My lords, will pass it properly. Let me matter back, my lords.
That's, oh, words of wisdom came from you, right? We are thankful to you. Thankful to you. Correct. No point in keeping as it is. You have suffered an order of stay. Correct. Thank you, Mr. You should have. We were dictating. You should have intervened and said it was not brought to our notice.
In fact, I wanted to, because your lordship said one by one it will be called. Therefore, I did that one.
But you should have said that before one by one. I want to make a submission. So don't pass any order in this thing. Item number. So you see, an effort being made by you. See, by adoption of arguments also of senior counsel.
Similar grounds are there. My consent order has been given. 1 minute.
We'll come to you. Item number
54.
54. Who are you, Mr.? I mean, petition.
Drug industry. Bulk drug manufacturer.
A company registered under Companies Act.
Yes, yes.
Mark the item number, madam, 50. 55 to 60.
Such an order has been granted, my lord, it is there up to 31/7/23.
No, no, 55 and 60 to 60.
In this matter.
Identical.
Identical.
Madam, in this petition, petitioner has assailed the validity of the composite order dated so and so passed by Telangana State Pollution. Yeah, that is yesterday. That we will do just now. Yesterday there was a Oh, yesterday's order, Mr. You tell Mr. Nagendra Reddy to file, huh? And he should be thankful to senior counsel for. It happens, right? I mean, no, but that shows that how important role the bar plays in the correct view being taken by. We are under pressure of work all the time. You have to.
We have to ask.
Then you should have said. That's why we said in the beginning that you had that order.
Whether it was a composite or order or not, that I was not aware.
Mr. Your order is composite order, right? Correct. Composite order.
Composite order.
53 composite order or not?
53, I'm applying.
Huh?
53 is the party to the OA. Petition is the party to the OA.
Composite order.
Composite order, section 31 and 33 of the 53 Nagendra Reddy's. Yes, Nagendra Reddy's matter I'm appearing.
Goes back to you.
Yes, Mulad.
Each order 53.
53, Mulad, in that senior, learned senior courts will argue that is the petition is not.
He has not argued 53, he has argued 54, Mr.
Not 53, I am 53.
We are asking about 53. If you have some information, say, otherwise we will find out.
Yes, no, information is the petitioner is the party into the proceedings and the OA pending in the green.
That doesn't make any difference.
Green tribunal.
The argument that
composite order or not is the issue.
Is a composite order, section.
Then the petition is maintainable.
33.
And then we are remitting the matter back to board. So which order in 53? 53 also this writ petition challenge the validity of the order dated. Mr.
23 March 2023.
Composite order, same order, madam. 23rd March. Reasons assigned that operative portion. And you tell Mr. Nagendra Reddy to file this review in WP 20623. We will allow that.
I'm appearing for the pollution control board.
No, true. You can.
Yes, I'll inform.
You are an officer of the court, right? Yes. You have to assist this court or not?
Yes, Milad, the respond.
Mr. Reddy is not your friend.
Yes, Milad.
He is.
Yes.
Will you not inform him that he needs to file a review petition, which the court has said that will allow in view of judgment of Supreme Court?
I'll inform.
Our order, yesterday's order is per incurium. Correct? We are also human beings, right? That's why power of review. You should tell him. Yesterday he agreed that I will file an appeal and all that.
Yes, yes.
That can't be done. Thank you. Yes. No, this.
We have come to hearing. Should you call the annual councils?
Pass over them. He said, I will argue the fund here finally. He said, give a date, no time left. Pass over next. We will start yesterday by 10 minutes. So that it will sit will go fun. Mr. Can't be heard today. Huh? Unlike Bangalore, this court works only till 4:30, not 4:35 or 4:45. So even those extra 15 minutes are not available. So please tell us, Hyderabad is a good place to come back. Please mention on the next date, we will take it up.
Next date.
Huh? On next date you should see. The bell also you heard. Which date, mister? You are in outstation council, that's why.
Sixteenth, my lord.
16th August. 29th August, 29th. And you know what to do. Huh? Prepare a synopsis. Huh? See, in Karnataka, I was not even required to tell. First of all, you people used to forward, sir, this is synopsis. If you want it to be heard at this stage, please cooperate. We will not, this thing, note down the facts.
No, I prepare the synopsis.
Short, this
Yes,
thing.
yes,
No,
yes.
synopsis means not 10 pages.
No, 1 page. List of dates here.
Correct. And you are at the bottom of its submissions in substance 1, 2, 3, 4 cases you are relying upon. End of the matter will conclude in the hearing.
Yes.
Right? Then it comes on 29th August. Mark their presence on account of paucity of time. The matter could not be taken up. List on 29th August 23. Do you record this submission, madam? What I dictated in the morning? You were there in this case? Somebody was there, no? I had recorded what his contentions were. So let it be there. Correct? Those submissions. Then say on account of paucity of time, it could not be taken up. List on whatever. 29th August. Yes. Yeah. That tomorrow's part third matter. Yesterday's part third matter, we were hearing that generating company thing. That, yes, we'll hear you for a while, see.
I could come around.
Fine.
Traffic that total 2 hours I was on the road. Reach here.
We were told that traffic in Hyderabad is better than Bangalore.
Yesterday because of the Balaji brothers.
Yes.
People jammed. I just couldn't, there's no way I.
Right. So we will hear you for a while. Yes. So we resume from where some. Yes.
Interpret 2161 at the last hearing for the other bench, I had given a very short.
Yes. We were shown yesterday by your colleague.
So 4 or 5 matters. Do not stay.
Yes, please.
The lordships find it other. I brought
No, we have. Yesterday, your colleague showed.
2161, my lord. In writ appeal 2161 of 2004.
Writ appeal 2161, madam.
2161, there is a small notes in this bundle. Yesterday's bundle also it was there. Small notes in the
But this writ appeal is the notes are prepared in.
This is list of dates. There is one.
With reference to the compilation, convenience compilation.
Yes, she has. Yes, she has. Give it, madam. This thing also. And written submissions are there.
2161. Your lordship, we just see on the last.
2161.
2161.
2161.
This is on the last page, my signature, my lord. My name is there.
Yeah. Yes. Nobody else would give. Yes. Yes, Mr. Chaudhary.
I can take your lordships through it.
Yes.
More structured. But this company, Andhra Pradesh Gas Power Corporation, was initially conceived by the APSCB because gas was available in the state. Then they said they have no money. And the government said, in 1987, there was such a power shortage. So those industries which require power, let them make the investment. And a special purpose company be set up. And let the companies set up, invest in it, set up the power station and use the energy which they were generating from that. So that is how APGPCL came into being in 1987. Now, at the time, That's a memorandum of understanding. So entered into. Right? What will be the shares allotted to industries? Some 15, no, at least 15%, more than 15% shares should be allotted to the APSCB at that time, so they can use the power for themselves. And the share, whatever is generated, will be shared by all these shareholders in proportion to the shareholders. Now, that was the first one. Now, your Lordship must see the convenience compilation at page 48 to 58 is the first one.
51 MOU starts.
48 to 58 is the first MOU.
Yes.
I just take your Lordship to two paragraphs. Page 52. Page 51 at the bottom. Participating industry shall invest in the equity share capital of APCPCL in proportion to their allotted share of power. AP Transco, TS Transco, but this names AP Transco, TS Transco have been amended subsequently. Originally it was APSCB. Because of the devolution operation of law, they were substituted. Shall hold not less than 15% of the paid up share capital. Then 3, this is where the rights come. The electricity, namely both power and energy to be generated by APGPCL, shall be shared between the participating industries and AP Transco, TS Transco in proportion to their paid up capital. Now, MOU 1 had a particular provision. This first MOU is with respect to the first 100 megawatt station that was set up. Only for that. All this applies only to this. This MOU has become part and parcel of the memorandum and articles of agreement of the company. Pre-incorporation contract, incorporated into articles. Paragraph 55, 17A. I am reading this out a lot because the learned single judge committed an error in relying upon this clause
17A.
17A instead of the applicable clause in MOU 2. The issue arose under in respect of the energy from the second stage covered by MOU 2. Now, it is agreed that power generated could not be utilized by the participating industries either full or in part. The Transco shall have the first claim to utilize it. What is true? From 1987, when this situation has arisen with respect to the power generated in the stage 100 megawatt generating station, they had the first right. When they were to exercise the first right, they were to exercise. It's a first right. So they had to extend that right. If wherever it has been exercised, they have been, that power has been given to them, it has not been redistributed among the other participants. Now, this is what happened in 1987 to be done. Now, please come to, if your Lordship have made, noted down the page numbers in my, the same page numbers which I have read out, I have noted down in my note, just for your Lordship's convenience. 1997, please turn to page 2 of my list of dates. In 1997,
One. Page 2 is some note. We just had. Yes.
Yes. In 1997, I've given all the page numbers, relevant page numbers with reference to this. In 1997, some more gas became available and they decided that they will set up another 172 megawatt. For the energy generated from this 172 megawatt, a separate agreement was entered into how it's to be shared. That is MOU 2, it starts at page 59. of the convenience combined. Now shift my turn to page 60. On page 60, just under the whereas that is saying, whereas APGPCL already owns 100 megawatt. Now, this is the reference to the previous stage, which is covered by MOU 1. Already owns 100 megawatt. Then just 3 paragraphs down, your lordships will get, and whereas APGPCL has decided to set up additional capacity of 172 megawatt. That's the last paragraph of that page. And whereas APGPL has issued equity shares to the extent of so much for the expansion project of 170. But these equity shares were issued to already existing shareholders holding shares with respect to MOU 1 and also others, other industries. So, there was now, after this, there was MOU shares which were linked to first stage, shares were linked to second stage, and the rights to energy running with the right in shares with respect to each of us. So, with respect to MOU 2, those who held shares there, in proportion to the shares held in the second issue of equity capital, they will get the power. That's my lords will leave. Now, my lords, they just turn to the provision on 66 where the real dispute arises. Page 66, clause 2.6. But I'm saying for this is operative from 1997. 1997, there has been no issue with regard to the manner this is operating. When the participant industry, for any reason, is unable to utilize its full share of energy from APGPCL, it shall give an advance notice of at least 15 days before the billing month. That is, whoever does not want to use his share must give that notice. Once he gives that notice, then APGPCL will reallocate it among the others, among the participating industries who wish to take additional energy, again, intersect, depending on the number of shares. Let me say, if 100 is available and there is a requirement for 100, then this 100 will be divided among those who require it according to the share. That is intersect. Intersect among those. So the shareholding concept and pro-rata concept is there here also. Reallocate the surrendered energy to the participant industry on pro-rata basis among those of the rest of their participants who require additional. Now, in the last sentence, however, when advance notice is not received by APGPCL within the stipulated period, the unutilized power shall be reallocated. What happens, my lord, is this? If somebody doesn't give that notice, this process of reallocation doesn't take place. So eventually what happens? Some power gets generated, but nobody to allow to. In such a case,
It goes to transfer.
it goes to transfer. The transfer gets advantage. It happens. The industry which did not get some power has to pay the fixed cost. Two elements of that. Fixed cost, variable cost. The penalty for the participant industry who did not use his share is that he still has to pay the fixed cost. And AP Transco gets the energy and uses it beneficially, he only has to pay the variable cost of fuel. That's all. This was no issue of this arrangement till 1998 was the first sign with the troubles. 1998, the Reform Act came into effect. Andhra Pradesh Electricity Reform Act. There were some provisions for a license. The then Regulatory Commission under that act took a stand that this APGPCL, when it makes a supply of energy to its shareholders, requires to take out a license under that act. But that came before this honorable court. A writ petition was filed. The industries, it was held against the industry, matter was back to Supreme Court. Supreme Court said, when shareholders are set up a project for themselves and for themselves, it is supplied from special purpose unit to themselves. It is the nature of a capital time. And for such a supply, no license is required. But there was a provision in one of the MOUs which said any industry would ask for allocation of its share to a sister industry. Sister industry means it's a separate entity under the same manner. Supreme Court said it is sister unit. It's a separate entity. It is not the entity which is a shareholder. Therefore, if that has to be done, the license is fine. But it was a clear decision. This was the only controversy. After the Supreme Court judgment came, there is some understanding. Supreme Court judgment came. 2003 Electricity Act 2000 came. Section 7 clearly says every generating station, anybody can set up any generating station without a license. Specific provision section 7. Section 9 says any group of systems can set up a captive generating plant for their own use. And they have the right to access of all the distributed transfer rights. This section 9 provision is this. Now, even in the Supreme Court judgment before 2003 Act came, the Supreme Court looked at the provision of 2003 Act and said, maybe it is defined specifically in 2003, but this captive generating plant is said to have not been a captive generating plant before 2003, even under the old rules. And therefore, the principle with regard to captive generation is that you can use your own energy. And a group of people sets it up and they get their energy. That's it. Now, after this judgment came, after the change of the act, they suddenly on one day decided that with surplus energy under from phase 2, APGPCL allocated in April and since 1997. Same way. What they did was, that this energy which is generated by APGPCL is carried by AP Transport and delivered. The same MOU provides for that to carry out the wheeling on a consideration of a wheeling charge. So they were actually acting in respect of energy delivered to them. Delivery to one of the shareholders, they were in a position of a common carrier and as they made it. They did not take any step of conversion of taking title to it. So what they did, April 2004 bill was also issued. Then sometime later, for no reason, without notice, they issued a revisal. The revisal says this surplus energy, whatever the contract is allocated to you, is ours. And we will bill you as if it is ours. Now,
so they said that it belongs to Transco. Surplus energy belongs to.
It is due with APGPCL. So, actually, what they were doing was,
And they would bill you what according to
the two things.
a tariff order.
Yes, they billed according to tariff order. Transco billed us according to the tariff order. The energy which was supplied to us, APGPCL. APGPCL, according to the MOU, set its regular bill for the energy supplied to APGPCL.
So you were billed according to the tariff order by APGPCL, correct?
Plus they were billed as per the tariff order. For the
That's
actual
what I'm saying.
consumption, they were billed as per APGP.
But not APGPCL is generating energy.
No. Question is lordship wanted.
I'm not.
Sir. The question that is being, the query is falling from his lordship is that so far as the actual consumption in terms of the pro rata sharing, the APGPCL has billed you as per their agreed rate. As per the tariff fixed by APG, as per MOU, tariff fixed by APGPCL in the format. The surplus what you have drawn without within that 15, without prior notice of 15 days, that the electricity board has
No, there is no prior notice.
no, that's what I'm saying. That
came up. They simply made a claim saying that all the surplus energy belongs to us.
So the surplus energy which has been drawn by the participating units, in addition to their entitlement, was billed at the tariff rate of the electricity board.
Correct.
That is what we wanted.
But that entitlement is controlled by clause 2.6.
No,
2.6, which I just read.
2.6 is the prescribes a procedure.
No, right now. Please read it again. Please, for my sake, read it again. 2.6.
So, no, what has been like, you have been for surplus energy, you have been charged tariff as per the tariff order.
By AP Transco, I have been charged at the APGPCL rate by APGPCL. So for the same thing, I have somewhat a double whammy.
Okay.
APGPCL said this is my energy generated by me. I allocated according to the MOU to you.
And for same energy, this Transco wants to charge you.
Have a claim. They have a claim. They have to raise it with APGPCL first. They can't raise it against me.
Understand Transco is also demanding tariff amount under the same surplus energy already charged by APGPCL. That's the submission. Correct me. That's the submission.
No, but if you see the terms of agreement, APGPCL will do dealing with the assistance and transfer. So for the units, what is agreed? Only they can ask for the submission, right?
So, for the same transaction, you are being taxed twice. Do we get it?
Yes.
Do you correctly? That by so by APGPCL, you have been already charged paid.
Yes.
You are resisting the demand in respect of same surplus energy by Transco.
Correct. That's a double whammy for us. And naturally, because I am a shareholder, I've invested in it.
So this
APGPCL
Transco is charging on what basis? We would like to know as a. From demand has been raised from you.
The method of tariff is on page 60.
No, not method. Just tell us on what basis Transco has made a demand from you.
They did not give any reasons, my lord. They issued simply arbitrarily one revised bill for April 2004, thereafter for every month thereafter.
No, so what this revised bill contains what? Charges for?
It just removes the surplus power.
Charges for surplus power.
Just one minute to explain how the accounting takes place.
No, we don't want to go into method of accounting, but we only want to know what is this revised bill for what? On account of supply consumption of surplus charge, surplus energy.
Surplus energy which was allocated to me by APGPCL, to that extent, they have charged me the normal tariff rate as if I have got the energy from them.
Allocation has not happened. The entire issue is that only whether allocation happened in terms of clause 2.6 or not. The method of allocation is prescribed under clause 2.6. Correct. Whether it has been done in pursuance of that clause or not is the issue.
That is not the issue they have raised.
But,
They have said that they had an overriding thing on 2.6. Please see 2.6 for a moment. But if you say that in a particular month, a particular process.
So will you, you have done excellently by this thing, for giving us all written submission and this thing. We request you to give tomorrow the issues also, formulate issue in your own language, say 1 and 2.
But lordships, just
1 and 2 issues like issues. In your own language, you formulate that this is the issue involved in these batch of petitions.
the basic thing is, your lordship see the judgment of the single judge. The fault, the fatal flaw of the judgment of the single judge is he has relied on a clause
which does not apply.
MOU 1.
1.
And then said the energy is this.
MOU 1 does not apply.
Does not apply. Then he said it is this. Now, then they say, then he said that that energy which has become theirs, they cannot fix the price by themselves. That price has to be fixed in consultation with the executive. My lord, that is the ground of their.
We file appeal.
That I agree with them, my lord, that the first one was wrong. The second part of it, which was what they are aggrieved by, is equally wrong. There's no doubt about that.
Yes.
First one is wrong.
Is there any difference between participating units under MOU 1 and the MOU 2?
There are, in the terms of who has got shares in respect
No, that's why I'm saying. You see, if you see MOU 2, it takes in AP GPCL, which has got the AP Transco, Telangana Transco, and 6 customers in the beginning. That is MOU 1. Now, when it comes to MOU 2, AP GPCL, which includes 2 plus 6 plus other 16 or 17, all of them have been defined as participating industries only. So there is no distinction between participating units in the first agreement under the first MOU and the second MOU.
One of the industries under the second agreement is limited only to all the industries other than AP Transport.
That's why I'm saying today, let us say if all put together you have 272 megawatt. Now the units who are not part of the MOU 1, are they entitled, let's say tomorrow, I'm just giving one of the clauses also says if there is a fall in generation, operator fall would be reduction in the power generation, correct? Now, let's say as against 272 megawatt, you are only producing 200 megawatt. Now, let's say the second unit is producing 172, while first unit is only producing as against 100, it is only producing 25. In which case, the proportionate reduction should only be applied to the shareholders of the first unit and 100% should be allowed to the second unit. Correct. Is that way it is done? What is the material placed before the court?
But that is not an issue, my lord. I can place the material. Material placing is one thing. Is that an issue?
That's why we have requested you to formulate the issues. Please give us 1, 2.
Just so that my lord does not think about this overnight, my lord. No. Answer him.
Okay.
That's it.
Yeah.
What I'm saying is,
more things to do.
it is not a question. The whole thing is not arising from saying, see, MOU 1, that is stage 1. Production went down. Stage 2, production retained. And therefore, I want to claim. This is not the basis. The claim is irrespective. I have a claim. Claim for the surplus energy in stage 1. I have a claim surplus energy in stage 2. That is what last time was argued on behalf of
no, but it is effect. The agreement also provides for that.
No.
2.8, look at 2.8.
2.8 refers to only energy stage 2.
No, similarly, similar clause is also there in your No.1.
But it will apply only to energy generated from the.
See, the reason why I asked that doubt question is because I had a doubt as to whether there is any distinction between the participating industry under the MOU1 and
The participating industry difference, there is a difference how stage one's energy is distributed only among to those relevant shareholders. Stage two only among those two relevant. These are put out to the rapid transport grid at two different points metered separately. They are metered separately.
All right, we'll continue tomorrow. Please formulate in your own distinct words the questions which arise in the context of the order passed by learned single judge and on the facts of the case and in the context of order. Please formulate so that we can proceed further. And we'll try to take it up tomorrow, afternoon.
Your lordships, just making a request for audit. I'll.
Yeah, this one, which year?
Yeah, okay.
Not CC. This petition is of which year?
This is of
Bunch.
I just wanted.
5 and 4, Mr. 5 and 4.
Yeah.
This is 2015.
No, there are so many other councils. Let them continue because
we will. No. We will with this thing. See, we will not conclude before hearing you.
No.
This is our predicament is there. Yesterday you were stuck up for a genuine reason, but our predicament is, we may sound unreasonable that you were only saying today, but today we don't know by what time the motion would finish. Then apart from that, another difficulty is that if we grant adjournment in 2005 appeal, we don't have a right to insist in 2010 matter that council should argue. That's the predicament as a judge, and that we have to be, we have to perform the unpleasant duty of being constant and take always a consistent view. That's why we will hear other councils. We will conclude day after if you so please come. All right. Thank you.
We want to make a request for us.
continuity also does
Continue.
break.
Do it tomorrow.
Thank you. Please. Thank you. We'll hear you tomorrow then. Yes.